Body.
Morning, Chairperson.
Yes, I'm dealing with the Eskom application for leave to cross-examine Mr. Koko first, who appears for Eskom.
Yes, they are here.
Hey, switch on your mic. Yes. Somebody will assist you. Yes, if it's, you can address me seated if that's more convenient there because of the mic.
Chair, Chris McConaughey appearing for Eskom. My
Yes.
leader, Mr. Locomotive, is currently acting in the Eastern Cape. But
Yes.
I've been assigned to today's application.
No, that's fine. Thank you. Mr. Berry, you appear for Mr. Koko?
Yes, sir.
I must say that I didn't come across any opposing papers for Mr. Koko, and I don't see them here. What is the position, Mr. Berry?
Those papers were filed long ago. They were made available to the Commission again today, this week rather. And I received a document this morning from Ms. van Vieren, which purported to be the paginated bundle, but I didn't check that to see whether all the papers are in there, including
Yes. Well,
Mr. Coker's opposing affidavit and Eskom's reply.
I was given the impression maybe a day or two ago that Mr. Koko was opposing and that there may have been papers, but I see that they are not here. What is
The bundle that I received this morning
has got them. Mr. Salega?
the bundle that I received this morning has Mr. Coker's affidavit from page 110.
Mr. Salega?
Thank you, Chair.
What's the story?
There is a bundle prepared, Chair, on page...
The one I've got here doesn't have opposing papers.
Chair, please check page 110. 110. I see they did the red pagination.
Oh, okay.
Yes.
But there is... Oh, okay, no, I see there is in this file, but I haven't had a chance to read it, but I think, let's see how it goes. Let me hear the legal representative for Eskom first.
Thank you, Chair.
Let him go to the podium. Please just repeat your name so I can make sure I've got it right.
Thank you, Chairperson. It is Chris McConaughey of the Johannesburg Bar for Eskom. And
That is, how do you spell McConaughey?
it is MCC,
Capital letter C, the second one?
capital letter C, that's correct, Chair.
Yes.
ONN,
I'm sorry?
ONN,
O-N-N.
ACH,
O-N-N-S-C-H.
Sorry, Chair, A for Apple, A-C-H-I-E.
McConaughey.
McConaughey, that's correct, Chair.
Okay. Is it
Chair,
she
if it-
or key?
Key.
Okay, all right.
There's a long history, Chair.
Okay.
Chair, if it would assist, we've prepared a short note for argument, which, apart from setting out the correct spelling of the surnames, also includes a brief synopsis of the case, which might
Okay,
also assist.
let me
If I can
have
beg leave
that.
to hand up.
Yeah. I'm sure everybody was given an indication that I didn't think we should take too long on the matter.
Indeed, Chair.
Thank you.
And we hope the note for argument will expedite things. I certainly don't intend to read or to take you through it in any detail, but it's designed to simply capture the key crisp points and
Yes.
also to summarize the essence of the application.
Yeah, I'll tell you what my concerns are, because if you persuade me on those concerns, then I would hear what Mr. Berry has to say. I don't know whether Mr. Selega intends saying anything, and then we'll take it from there. As I understand Eskom's application, basically they are concerned that Mr. Gogo has given the impression or given evidence to the effect, or that suggests that they had no proper grounds for taking disciplinary action against him. That seems to be the main thing. Am I correct?
Chairperson, it might assist if I start by dealing with those accusations that have implicated Eskom, and there are two parts to that.
Yeah, but I want to characterize the basis first. Is that correct? That's the main basis.
That's the first basis, Chair.
Yeah,
There's
what
a
is
second,
the other one?
There's
Yeah,
the second,
what is the
and
second
perhaps even more critical,
Yeah, which
is
one
the
is that?
allegation that's repeatedly been made by Mr. Koko in his affidavit and in all the 9 hearings,
Yes.
that Eskom misled the High Court regarding Mr. Koko's role in the McKinsey MSA transaction.
Yes.
And the various imputations that he's made of dishonesty against Eskom.
Yes.
But also, we would submit, Chair, very serious accusations made against the 3 judges of the full court
Yeah.
in Pretoria,
Yeah.
who Mr. Koko suggests were part of what he's colorfully termed the Koko hunt.
Yeah. Okay, no, that's fine. To a very large extent, that doesn't disturb the concern I want to put to you. And that concern is this, that when the person who is applying for leave to cross-examine complains that a witness has implicated them in corruption or state capture, that's an easier application to grant. This one doesn't appear to fall within that, as I see, within that category, as I see it. This one seems to revolve around saying, in effect, what this witness has said about us is factually not true, or is just not justified by the evidence, Now, my inclination with regard to matters such as that is to say, this is an inquiry. You've got evidence leaders who lead the evidence and who act or perform their duties in terms of, among others, rules that say they need to question witnesses with a view to establishing the truth. In those circumstances, and more so, of course, with where we are now in terms of trying to wrap up the evidence, there may be difficulty in seeing why it's in the interest of the work of the commission, and of course, that's what the rules say, why it's in the interest of the work of the commission to grant leave to cross-examine. Mr. Koko is one of those witnesses who has appeared here many times and has been questioned for a long time by the evidence leader of the relevant work stream. Of course, the inquiry functions on the basis that if, for example, an employee of Eskom, official of Eskom, or former official of Eskom is before the commission and gives certain evidence, Eskom is entitled, if it thinks that the evidence is not correct, to place or give the commission evidence that will give the correct picture so that the witness can be questioned on the strength of all the evidence. But also, Eskom would say, well, or could have said, well, if this witness of ours hasn't been led, we suggest that this witness be led because he or she will then be able to put the correct picture. So my inclination with this category is that I'll struggle to conclude that it's in the interest of the work of the commission to grant leave. So that's what I wanted to put to you, but you can address me.
Thank you, Chairperson. I appreciate that steer on your concerns.
Yes,
I intend to address those concerns directly in three parts with your leave, Chair.
Yes.
The first is that very important concern about the allegations that Mr. Koko has made and whether Eskom could truly be categorized as an implicated party in terms of the rules, which I believe would be your first concern, Chair.
Yes.
The second concern then relates to the proposed line of cross-examination that Eskom proposes to address those allegations. And the third link to that is why that line of cross-examination would be assisting the Commission in wrapping up its work and be in the best interest of the Commission. So, Chair, and in the course of that, I hope I would address the concerns.
Yes.
If I may start then, Chair, with that very first point that you raised with me, and that is the question of the allegations, the implications. Chair, we've summarized those allegations again for your reference at page 4 of the note that I handed up and onwards.
Yes.
And I don't intend to take you through in any detail through the various allegations that Mr. Koko made in his affidavits and before in this hearing.
Yes.
But I think the pertinent point you put to me, Chair, is how does that implicate Eskom?
That's right, yes.
And if I may start with the first allegation that Mr. Koko raised.
And the implication might not just be implication, but implication in the kinds of allegations that the Commission is investigating.
Indeed, Chair. Indeed.
Because otherwise, if it's just some implication that doesn't fall within what we are investigating, there might be a problem too.
Indeed, Chairperson.
Okay.
If I may start with that first allegation. Chair, you will recall that Mr. Koko, in his evidence on 3 December, suggested that Eskom had fabricated the disciplinary charges that he had faced in January of 2018. And he made the pertinent allegation that they had fabricated these on the instructions of the then Deputy President. And the suggestion was, in essence, Chair, one of almost reverse state capture, a form of interference in Eskom's functions, which resulted in Mr. Koko's words, a baseless set of disciplinary charges that were put to him in January of 2018. Those are the disciplinary charges, Chair, that Mr. Koko, in the course of his disciplinary hearing in February of 2018, he resigned 30 minutes into that hearing rather than answering to those charges. But nevertheless, he's used these proceedings to perpetuate this narrative that those charges were baseless and had no substance, even though he, in essence, ran away from those charges, Chair.
Of course, it's not unreasonable to think that a bystander could well think that he was running away from facing those charges. which would not be consistent with any allegation that those charges were without foundation.
Yes, indeed, Chair. But he's used these proceedings to, of course, attempt to present a different narrative that he...
No, I understand that, but what I'm saying is that mere point could well send a message to the public that doesn't support any allegation that Eskom had brought baseless charges against him. Because if they were baseless, why didn't he meet them head on?
Indeed, Chair. We would hope that that would be the reasonable inference that someone would draw. But the implication that Mr. Koko and the allegation he's continued to make is to say that...
Of course, you may appreciate why it's relevant for me to raise that.
Indeed,
that is
Chair.
simply because it may dilute the strength of your case insofar as you say, this person says we brought baseless charges against him. So insofar as it goes to that, you have a situation where by his conduct, the public might not, or at least some of the public might, part of the public might not believe that.
Chair, that is the inference we would hope would be drawn, but
Yes.
of course Mr. Koko has presented a very different version in front of this commission.
Yes.
And it goes to the point of implication, because Mr. Koko has in essence inferred that the board of Eskom breached its fiduciary duties by putting together trumped-up charges based on external interference, which of course, Chair, is a very serious criminal offence that goes to PFMA obligations of the board, its fiduciary obligations, which are backed up by criminal sanctions. So we would suggest to the Chair that certainly is an allegation which is very much at the heart of the Commission's work. And indeed, part of course, the Commission's role is not only to address that maladministration that has occurred, but also to support efforts to uncover maladministration. And indeed, Mr. Koko's allegations call into question those efforts. But Chair, the second and more important allegation which Mr. Koko has made is, as I mentioned initially, the persistent allegation that Eskom misled the High Court, and that the High Court itself was misled regarding Mr. Koko's role in the Master Services Agreement. And that's a thread that runs between the first and second allegations. Mr. Koko, of course, tells the Commission repeatedly that he had nothing to do with the Master Services Agreement. In his own words, he said he had zero role whatsoever. And he also denies any involvement in facilitating that agreement, its settlement, or the 1.6 billion rand that was ultimately paid out unlawfully to McKinsey and Trillion. But Chair, Mr. Koko has in his affidavit initially told the court to quote, and this is his original affidavit to the Commission, paragraph 230, he says, quote, Eskom clearly did not make proper honest disclosure to the court. But in his submissions to the court, to the Commission rather, on 3 December, he went further to then make very serious allegations against the court itself. Where, Chair, on 3 December, Mr. Koko, it's a long passage which I won't give to the court, but we summarize it at page 6 of the note. In essence, again to quote, says, the members of the court, with full bench, was caught in the state capture theory, which was his quote. In subsequent proceedings, he's doubled down on those allegations, Chair. He's gone on to, and this is a quote taken from his proceedings on the 4th of May this year, which we've quoted at page 7, paragraph 12.7. He suggests, and I again quote, and I think the gossipers and the people that are on the Koko hunt missed it, the various allegations, including your colleagues at the Pretoria High Court, which is one of the very painful things to me because they've concluded there was a corrupt relationship. And I'm saying to you, if they had regard to the evidence that you now have, they would have reached a different conclusion. So, Chairperson, there are two very serious allegations combined in there. The first is one that says Eskom, in its efforts to address maladministration and corruption, has in effect committed grave breaches of its duties, it's lied to the courts, and Mr. Koko seeks to exonerate himself. But he also then makes very serious attacks on the integrity of the judicial process and the courts themselves.
You see, insofar as the basis for Eskom's application is, this man has said we have behaved badly. you know. I don't see why it's not enough to leave it to the evidence leaders to put the correct picture to the public, you see. Whatever bad conduct it is, if it's not corruption, state capture, fraud, you know. So, because imagine if over the past 3 years, I was granting applications where that's the complaint, how many people would have occupied the time of the commission, you know. So that's my difficulty, where you are not implicated in acts of state capture, corruption, and fraud, because I think primarily the rules seek to afford that category of people, you know, this opportunity of cross-examination. It may be that technically it's not like that, but in the end, when one considers the interests of the function of the commission, the work of the commission, it seems to me that it's reasonable to say, look, as far as possible, if your complaint is simply that somebody has said you have lied about them, that kind of thing, that should be sufficiently taken care of by the fact that there are evidence leaders of the commission who, in terms of the rules, are directed to question witnesses with a view to establishing the truth, you know. So that would be my inclination. Okay.
If I could give two responses, Chairperson. The first response is that these allegations we would submit do amount to a form of allegations of state capture. The first allegation is that Eskom put together trumped-up charges on the basis of purely external political interference. And the second is that Mr. Koko is the victim of a grand conspiracy, a conspiracy hunt, where he has been maligned, and in fact Eskom has misled the courts about his role in state capture. So, Chair, we would submit that both of those are, again, accusations leveled at the Eskom board and the Eskom directors, which suggest grave breaches of fiduciary duties, which of course go to the very core of this Commission's function, around the proper functioning of state, organs of state, parastatals, and ensuring that maladministration and corruption is adequately addressed and nipped in the bud. But, Chair, the second point, and the question you've put to me, a very important question, is it not enough that the evidence leaders have led the evidence? And that brings me to the second topic which I intended to address, and that is the line of cross-examination Eskom proposes. Because, of course, Chair, we do not for one moment seek to undermine or criticize the evidence leaders for the manner in which they presented the evidence before the Commission. Eskom's line of cross-examination is instead aimed to build upon and to complement the line of examination that Mr. Seleka and others have already presented. But what we suggest, Chair, is that there are two important gaps which would be important for the Commission to fill and to at least have a proper version in front of the Commission. The first, of course, Chair, is that none of those very serious allegations that I've addressed have encountered any response, a forthright response thus far. Mr. Koko has had 9 separate occasions in front of the Commission where he has voiced these allegations. They've all been left in the air, which of course leaves a significant taint both on Eskom and on the integrity of the judicial process that Eskom pursued. But, Chairperson, the second part we would suggest is that what is underlying all of Mr. Koko's allegations against Eskom is his persistent allegation that he had no role to play in the Master Services Agreement and the unlawful payments that flowed from that. And that is what we propose would be the crisp focus of Eskom's line of intended and proposed cross-examination.
Of course, that's one of the things that at the heart of what the one of the features of what the Commission is looking into in relation to Eskom. And of course, he has been questioned quite extensively on that.
Indeed, Chairperson.
It might not be to your liking or your client's liking, but he has been questioned, and the questioning, as I understand it, he may still be required to file. He might still be sent written questions and file written answers under affidavit, but that has received quite some time has been devoted to that, isn't it?
Chair, we addressed that point at page 8 and 9 of the note, and indeed we could not suggest that Mr. Seleka has not addressed Mr. Koko's role, and he's indeed put questions to Mr. Koko related to that role. But what we suggest, Chair, is we've listened very carefully to the questions and Mr. Koko's answers. We've studied the transcripts, but we submit that there are additional lines of questioning which would be important to pursue to ensure that Mr. Koko is put to the sword, in essence, and to commit to a version. Because Mr. Seleka has, of course, elicited some very telling responses from Mr. Koko, but there are a number of loose threads connected to three main topics, Chair. That is Mr. Koko's initial role in the negotiations, his role in the settlement process, and his role in the payments. And we've outlined, Chair, a couple of illustrative points where we submit that there is need for a focused cross-examination of Mr. Koko.
Yes.
In a way which, of course, Mr. Seleka, as an evidence leader, would not be able to delve into that.
Yeah, I don't want to duplicate that. I don't want to duplicate that.
I certainly won't. But,
Yeah.
but if I could give you one example, Chair, as an illustration of where we believe that Mr. Koko needs to be...
Well, maybe
put to the sword.
don't give it to me, but I can tell you that you are most welcome to approach Mr. Seleka and make suggestions of areas where you think as Eskom would like him to consider, to say we would like to consider the following, but that won't, I don't think that would be good enough to grant leave as such, because that's something that falls squarely within what the evidence leader is dealing with, and it's something that the Commission is dealing with as well.
Chairperson, certainly, Eskom has provided assistance to the evidence leaders team, and but we understand, at least from the 19th of May, the final closing portion of the hearing with Mr. Koko, that was the very last time that he will be called to the Commission, unless the application for cross-examination is granted.
Certainly, I think that in terms of him appearing, I think what was said was that subject to cross-examination, he wouldn't be called back, but not only he, but there are a few other witnesses in respect of whom arrangements have been made that they would be sent written questions and they would be obliged to provide responses by way of affidavit. So that could be taken care of. Obviously, it's not the same as questioning and when a witness is on the witness stand, but this is a commission of inquiry. It's not litigation. So some of the things, one has got to balance a lot of factors. But I've given you, I think,
Indeed,
more than enough time.
And if I may just conclude by
Yes.
briefly addressing that last point, Chair, why it would be in the Commission's best interests. And that comes to the nub of it, that Eskom proposes a crisp, focused set of cross-examination of no more than 3 hours, which would be led by Mr. Locomotive, who is steeped in the facts. He was briefed for Mr. Koko's disciplinary inquiry. He was also the lead counsel in Eskom's review application to set aside the MSA and various other contracts. And the proposal is that because Mr. Locomotive is so deeply steeped in the matter, he could render great assistance to the Commission by focusing on those final loose threads putting it to Mr. Koko, and for once and for all, getting rid of the incredibly negative aspersions that Mr. Koko has cast, not only on Eskom, but also on the judiciary. And we would hope, Chairperson, that after Mr. Koko's 9 separate appearances, 3 hours would certainly be enough, and it would be more than just in the circumstances to allow Eskom to assist the Commission to finally put to bed Mr. Koko's very, very serious allegations. Chair, we would also suggest that, of course, we understand that there will be opportunity for further written questions to be put to Mr. Koko. But we would submit, Chair, that a witness cannot come and both seek to exonerate himself, which goes to the core of the functions of the Commission, but in doing so, issue very serious allegations of state capture and unlawfulness, and indeed criminal offences against those who have sought to bring him to book and to ensure that he's held accountable for his actions. So, Chair, in those circumstances, we submit there would be of great assistance to the Commission to make those focused submissions. And, of course, it would be a complement to written questions that might be put to Mr. Koko. But 3 hours we would submit, presented by senior counsel who has for years been up close to these matters, would be of great assistance to the Commission in concluding its work. So, Chair, those are our submissions. I'll listen carefully to Mr. Barry, and if needs be, I would ask leave for a very brief reply, if that would be in order.
You might not get a chance to reply.
It is in your hands, Chairperson.
Yes, we have got to use the time that we have properly. I'd hope that we would finish at about 20 past. We have gone beyond that, but because I am clear in my mind, I won't need to hear any further argument. The application is dismissed. I won't give reasons, but if they are asked for, I will grant them. I will give them. Thank you. Thank you. Thank you, Mr. Makunati. Thank you.
Thank you, Chair. I will then be excused.
You are
I suppose,
excused.
Chair. Thank you.
Yeah, you're excused.
Thank you.
Okay. Mr. Berry, you are excused as well.
Thank you, Mr. Chairman.
Thank you.
And we will, in due course,
Thank you.
submit the written responses to what has been put to us by Mr. Seleka, I think also during the past week.
Okay, no, that's
I
fine.
think we committed ourselves to the 10th of June for that purpose, and we will do our best to comply with that. Thank you, sir.
Okay, thank you, thank you. Mr. Maybeck, do you need me to adjourn a bit for 5 minutes?
Yes, please,
Yes.
Chairperson.
Okay, I'll adjourn for 10 minutes so that we can start with the day's witness. We adjourn. sorry that it didn't happen. Thank you. Mr. Singh, good morning to you. The oath you took yesterday will continue to apply today.
That's fine, sir.
Okay, thank you.
Thank you, Chair.
Let's continue, yes.
Mr. Singh, could I ask you please to go to bundle 5B, your exhibit, and to turn up page 1039.
Yes.
You recall that you asked yesterday for an opportunity to reflect on this memorandum
Yes, sir.
overnight.
That is good.
You have an opportunity to do that?
Yes, sir.
Right, please go ahead.
Sir.
Please go ahead.
Good.
I'd asked you specific questions that
Oh,
you
yes,
held over.
Okay, in terms of, if I recall correctly, you wanted me to respond to the fact that this was a new procurement event. That's correct?
I wanted you, yes, that was amongst the questions. But you can address that.
I don't know whether it's all of us, but it seems that nobody is as audible as they ought to be, at least to me. Maybe you are saying the same about me. I don't know, maybe
No, I can hear you.
go closer to the mic, I don't know, but it just seems it's not as audible as it should be. Maybe the technicians can attend to it. Okay, Mr. Mybeck.
Thank you. Yes, Mr. Singh, that is amongst one of the things that I wanted you to consider. Please go ahead.
So, Mr. Chair, in terms of it being a new procurement event, Mr. Chair, as you would see, this has been contemplated as a contract extension to the previous contract that, or to the contract that we had with regiments. So in that vein, Mr. Chair, it seems not to be a new procurement event. As I explained yesterday, it was, there were two streams. There was a advisory stream that provided advice on the cross-currency swaps, and then there was a advisory stream that provided advice on the actual raising of the funding with China Development Bank in terms of reducing the cost of funding and reducing the cost of the cross-currency swap. So it was advisory in nature.
So, as I understand it, they executed this fundraising task, is that right?
Well, as I said yesterday, Mr. Chair, it was not executed by them. The counterparties to the actual transactions would have been JP Morgan and would have been China Development Bank. But what they did do was provide advisory services in terms of reducing the cost of funding relating to the cost associated with the China Development Bank loan and the cross-currency swaps that were eventually executed with JP Morgan. And that is outlined in the document, Mr. Chair. If you would like me to take you to
Well,
that.
let us go, if we may. So now you've told us they provided advisory services in reducing costs. Could you can keep that page open, but can I ask you, please, to go to EB3A. I remember earlier in your evidence on this issue, you referred to MSM 177. That's the letter of the 20th of January where you made, your handwritten notes were affected on it. Do you recall
Yes,
that?
yes.
Please would you turn up 177 MSM?
17.
177. You indicated to us yesterday that the effect of the handwritten annotations at 180 was that fundraising was excluded from this contract. Is that correct?
That's correct.
So let us just see what it is that regiments were to do, having taken over from Nedbank. Would you go to 179 at paragraph 235? Amongst the deliverables was at 235, evaluating all potential funding sources and mechanisms to select the most appropriate avenues to pursue and execute. Is that correct?
Sorry, that's it.
235. So their job as an advisor, having taken over from Nedbank, was to evaluate all potential funding sources and mechanisms to select the most appropriate avenue to pursue and execute.
And that is correct. Evaluation would probably be in where they would look at what was available and select.
And 236, assist in the preparation and management of capital raising related tenders, RFPs, RFIs, correct?
That's correct.
And at sub 3, participate in the negotiation of commercial terms of funding from the shortlisted funders.
That is
correct?
that is.
Singh fading away.
I said that is correct, sir.
Right. Now, what we do know is that they were allowed to work on this project for about 12 months without a contract that you've accepted.
Sorry, sir.
They were allowed to work on the task for 12 months without a contract. And one was put in place, or an extension was put in place ex post facto, correct?
Yes, sir.
And can we deal with the question of whether you were under any legal obligation to pay them this success?
Mr. Chair, in terms of the document that in terms of the arrangement that we had with the regiment time, this was part of the original scope of work. As I said, it was de-scoped during this period of time as when this LOI was signed, with, due to the fact that it was not appropriate for them to engage in this type of activity at the time. But it was always an understanding that they were going to be able to assist in the execution of the funding. So from that perspective, there was an understanding.
Yes, but I mean, were you obliged to pay them this amount?
In terms of the work that was executed, yes.
The work had already been done.
Yes.
Then they came to you and they proposed that you pay them 166 million.
No, it was on the basis that the work was being done at risk.
Yeah. I see. And when it was agreed that, who agreed that the work would be done at risk? You?
Well, in terms of the understanding out of this LOI, it was de-scoped at this time. At this point in time, it was de-scoped, but it was not on the basis that the work would never be done.
It was rescoped, it didn't provide for it.
Sorry, sir?
It was rescoped in the sense that it didn't provide for it, it gave a fixed fee.
No, I don't think the fixed fee included the issue of the actual fundraising in terms of the mandate that was then concluded.
Yes, well, that's really what I'm getting at. Was this fundraising? Because
No.
just now you said it wasn't fundraising, you said it was advisory service.
In terms of the advisory services that was performed by regiments relating to the cross-currency swap and the JP Morgan, the cross-currency swaps with JP Morgan and the China Development Bank loan.
Mr. Singh, did it involve fundraising or not?
No, Mr. Chair, this related to advisory.
Advisory services. And you say it fell outside of the 20 January document.
Yes, sir.
All right, do you have any other comments you want to make on the memorandum at 1039?
Other than the fact that the memorandum covers the value that was added through the process, I think you also raised a question yesterday relating to the...
I'm sorry, Mr. Mabek, are you going back to Band 5?
Yes, the memorandum 1039.
1029 or 1039?
1039.
39, yeah. Okay.
I think there was one additional question that you had relating to a query by a certain Mr. Bloom, I think it was.
Yes.
I did have opportunity to reflect on that. I have not seen Mr. Bloom's comments. I just take it on face value in terms of the manner in which you've proposed it to me. You would have regard for the fact that I did say there were two streams of work that was performed. One was advisory relating to the cross-currency swaps, and one was advisory relating to the reduction of the cost relating to the China Development Bank funding facility. So from that perspective, there is two different streams of work that was performed by regiments, and that may account for the difference in the expected fee that Dr. Bloom was referring to versus what we had actually paid.
All right. Now, can I take you to the related evidence of Ms. Vagatho? And that you find in Exhibit BB10. Now, perhaps I could, sorry, if you could turn, I'm going to pick up from page 29. Mr. Singh, perhaps I could just summarize aspects of Ms. Vagatho's evidence. You've dealt with it in an affidavit, and then we can go through it in more detail. But, I mean, essentially, the point that she makes is that, in her view, there really wasn't a need for regiments. She gave evidence about a trip to Beijing with you in July 2014 to meet China Development Bank. She testified about the fact that when she returned from Europe after further international travel at the end of July, she was shocked to find out that Regiments was on the scene and negotiating with CDB. And then she talks about various emails and memos that she sent to you and Mr. Malefe about her concerns regarding regiments. And it's that exchange where you put in a memo, she put in a memo, it was noted by Mr. Malefe, and then she ends off by referring to the conclusion of the CDB agreement. You've studied her evidence, I take it.
The relevant paragraphs that was referred to in the 10.6.
All right. Well, let's go to at page 29. She talks about at paragraph 113 a trip, and that takes us to 115. She says, on 1 July 2014, Anoj Singh and I attended the planned meeting with CDB in Beijing. The discussion started with normal greetings and introductions. As we were busy with introductions, a young Chinese official handed out a page dated 29 October 2013 to everyone in attendance with a list of names on it. You confirm that you had this meeting on the 1st of July 2014?
Mr. Chair, I don't offhand recall the 1st of meeting, July 2014 meeting, but I don't have any need to doubt Ms. Makato's version.
Yes, but you do presumably recall going to Beijing in July, together with Ms. Makato.
Well, the reason why I don't recall it specifically, Mr. Chair, is that I've had quite a few occasions to visit Beijing, not only for CDB, but other investor meetings as well.
But do you not remember the meeting you had?
I remember having meetings with CDB, but this particular one, I cannot confirm that I did or didn't have it.
So had you had other meetings before this with CDB?
I may have, so I don't recall.
And if you go to 116, she says, I may be
I'm
speculating.
sorry, I think Mr. Singh, Mr. Maibek was also asking whether you don't remember a meeting where you went there with her, with Ms. Makato.
No, Mr. Chair, there would have been occasion for me to have a meeting with CDB with Ms. Makato.
Or there would have
There would
been
have
more
been
than one or just one, as you recall.
I do not recall. I would
But at
assume
least
that there
would have been one.
that there would have been at least one.
Okay,
Yeah.
all right. Okay.
All right. She says at 116, I may be speculating, but given the demeanor of everyone who received the 29 October 2013 list, I suspected that a meeting might have been held on that day and that discussions and possible agreements might have been reached. What do you say to that?
Mr. Chair, as she says, she may be speculating. Mr. Chair, I don't recall this 29 October 2013 list or the nature of the meeting that would probably potentially occur on the day.
Had you gone to Beijing and had you attended a meeting with CDB before the 1st of July 2014?
Mr. Chair, as I say, I will be really speculating. As I said, I've been to Beijing on a number of occasions for CDB meetings particularly, and other meetings relating to investors as well. So it could possibly be true, but I cannot completely confirm that if I was there on the 29th of October.
Then at paragraph 121, she says, we continued with the discussions, though we had to start from a zero base. The discussions lasted the whole day. We finished between 4:30 and 5. As we were making our way out, Anoj Singh requested to have a private discussion with the executive in charge of the CDB Henan branch, together with an interpreter who was fluent in English. The meeting lasted approximately 30 minutes. You want to comment on that?
Mr. Chair, there's nothing unusual around the CFO having a discussion with the counterpart of the bank, and the discussions, I would assume, would have been around the fact that we're discussing the, let's call it, more strategic relationship between China and South Africa and Transnet, and the impact of the how can I say, the impact that the loan would have in terms of the South African environment and the country. So it would have been discussions around the more strategic nature of the relationship between CDB and Transnet.
All right. Then at paragraph 122, after the meeting, Anoj Singh told me that his travel plans had suddenly changed and he was no longer traveling back home with me the following day. He indicated that he will be traveling via London to South Africa that same afternoon. He then requested me to collect his suitcase, which he had left in his hotel room before I leave for South Africa. Following day, before I booked out of the hotel, I picked up Anoj Singh's red suitcase from his room. I travelled back home with my luggage and his red suitcase. I don't know what was in the suitcase. Oh, sorry, I don't know what his suitcase contained as I didn't open it. You want to comment on that?
Mr. Chair, I deny this ever took place. I don't recall ever giving any of my luggage to anybody, and it's a highly strange thing for her to say, but as I said, I deny, I don't recall.
She says at 1:23, when I landed at OR Tambo Airport, I thought I'll take the suitcase with me when I go back to work. However, when I switched my cell phone on, I received a message from Anoj Singh that his driver will collect his suitcase from me at the airport. When I entered the arrival hall, I met Anoj Singh's driver, who collected the red suitcase from me?
Well, Mr. Chair, I don't have any recollection.
You have now, or did you have then a red suitcase?
Not that I recall.
Well, when I read this, or when I had her give evidence, the thought that crossed my mind is why you would have asked her to take this suitcase with her instead of traveling with your own suitcase. It seemed strange to me.
Well, that hence me saying it seems strange to me too, Mr. Chair. As if I was going to London, what did I go to London with?
Chairperson, sorry, we can't hear you.
Even me.
We couldn't hear the question that you posed.
Oh,
If you
okay,
can please
okay.
just repeat it so
Oh,
that we can
okay.
hear it.
Well, I just said to him when this witness gave evidence and when I read the affidavit, it seemed a strange thing that he would have asked somebody to take his suitcase and come back to South Africa with the suitcase, and he went via another route. So his response was it's strange to him as well, because why? What would he have taken with him to London? That's what you said.
That is correct, sir.
Yeah. Of course, the other question is, it would also be strange, would it not, for her to fabricate such a story, isn't it? It's to say somebody asked me to take their suitcase with me while they travel somewhere, and when I arrived at OR airport, I thought I would take it home and then come to work with it on Monday or whatever, next working day. But then there was a message, he said, somebody will pick it up, and somebody picked it up, and that's where it ends, because that's where it ends. Nothing turns on the whole thing. But it's not the kind of thing one would expect somebody to fabricate.
Well, equally, Mr. Chair, it wouldn't be something that I would request from someone to do. And Mr. Chair, I mean, I'm not too sure why she would do this, Mr. Chair, but again, if you look at the procedures at the airport, Mr. Chair, one of the things that they would ask you is, are this all your bags? Are you traveling with your own bags? Did anyone pack your bags for you? So she would have had to make these declarations. How did she make those declarations at the airport?
But would she be somebody that you would have thought she would fabricate something against you in terms of your relationship?
Well, as I've characterized my relationship with her, it was cordial and professional. So,
Yeah. Okay. Mr. Maivek.
Thank you. And then to pick up at page 31, I'll fast forward to paragraph 126, under the heading Regiments Taking Over the CBD Negotiations. Upon my return from Europe, which was around in July 2014, I was shocked to find out that CBD was now communicating directly with regiments and that Eric Wood was leading the negotiations. This was in parallel to Transnet furthering negotiations with CDP. Do you want to comment on that?
yes, Mr. Chair, I think at this point in time, I think we need to understand the context. And I think, again, the context at this point in time was that given the fact that we had signed the Locomotive agreements in, I think it was March 2014, the Locomotive agreements that we had signed created a commitment for us to be in a position to pay against the Locomotive agreements. Now, one of the criteria that the rating agencies employed at Transnet, I think it was particularly S&P, was a ratio called an AB ratio. And the AB ratio basically looked at the committed funding facilities that any entity would have versus the commitments that that organization had in terms of being able to pay. So they would basically look at and say, okay, your cash from operations is X, your committed facilities from banks is Y, your committed funding facilities is Z, add all of that up if it came to 10. And if you then had capital commitments or contractual commitments to pay, they would then add that up, and if that came to, let's say, 5, then your AB ratio was 2:1. And that is the ratio that they would, that is one of the ratios that they actually was quite particular about in the case of Transnet, because we were in a significant capital expenditure program at the time. And so we were under significant pressure to be able to demonstrate to SNP that we had a AB ratio that was acceptable to SNP. In terms of the Treasury function at the time, Mr. Chair, Ms. Makato and the team had been reaching a point where there was not significant traction on the discussions that were happening with China Development Bank. And then this is where, at the point at which I then decided to get Mr. Wood involved and regiments involved to understand to what extent they can actually accelerate the process and the discussions with China Development Bank with a view to conclude a transaction with China Development.
So at 127, she says, I again complained bitterly to both Anoj Singh and Brian Malefe, as I believe there was no need to use regiments because of our internal treasury capacity. And then at 128 and further, she says, Anoj Singh and I continue to argue about the CBD pricing proposal. And that then, if you look at 131, gave rise to a meeting with Mr. Malefe. Would you agree with that?
Again, I don't recall this meeting, Mr. Chair, but I have no reason to just believe Ms. Mahato's version of the meeting.
So at 131, Brian Malefe, I beg your pardon, organized a meeting between Transnet and regiments to resolve the CDB pricing proposal impasse. The meeting was held at the Melrose Arch Hotel. Transnet was represented by Mr. Singh Malefe and myself, regiments by Eric Wood and Niven Pillay. Is that right?
That's
And then she records that Mr. Malefe suggested that everyone seemed to think that my pricing indication is off the mark and that the one that Eric Wood received from Nedbank seemed reasonable. I should agree with them, as I was the only one who didn't agree. I told Brian Malefe that my position had not changed and will not change, as the CDB facility is expensive and not worth it. Do you confirm that that was the stance that Ms. Mahato adopted at this meeting?
Mr. Chair, as I said, I do not recall this meeting. But again, if Ms. Mahato says the meeting happened, I would take it on face value.
Then at 1:33, I then decided to record my recommendation and concerns. On 21 August 2014, I sent an email to both Brian Malefe and Anoj Singh detailing my key concerns. Can we just go to that email, please? That you find at page 241, MEM 241. So at 241, in the email that she addresses to you and Mr. Malefe, in the first paragraph, she says, this email is a follow-up of various discussions I had with yourselves, and in some instances with regiments included, where I'd indicated my discomfort and disagreement on how the China Development Bank facility negotiations are being handled, regiment's pricing methodology, as well as my disagreement of the appointment of regiments as the transaction advisor for the facility. For the avoidance of any doubt, I'd like to bring the following to your attention. And her first point is, in respect of your executive authority and powers that go with it, I respect your executive authority and powers that go with it, but I also believe that it is my responsibility as the current Transnet Group Treasurer to advise you on matters relating to Treasury activities. As I indicated, I was not consulted, nor was I aware that Regiments was appointed as the transaction advisor and lead negotiator for the facility, as I believe there is no need for them to be appointed given the progress that we had made. You want to comment on that?
Mr. Chair, I think again here, the reason that regiments, or Ms. Makato refers to regiments being the lead negotiator. When we had the discussion with China Development Bank in terms of having regiments part of the team to be able to negotiate and conclude the transaction, there was a request from them that said, listen, we understand that we're dealing with Transnet. To the extent that Transnet requires us to deal with any other party, there would need to be a letter from us that actually recognizes the identity of the other party. And from a bank's perspective, the only other people that they would engage with, other than the, let's say, principal, which in this case would be Transnet or Transnet team, would be people that they recognize as lead negotiators or lead arrangers. So that's the reason we sent a letter to CDB, or I sent a letter to CDB, informing them that regiments would be part of the team as lead negotiators together with Transnet.
But do I understand your evidence crisply really to be that as far as you were concerned, Treasury didn't have the capacity to handle this sort of transaction?
Well, ostensibly they failed to have reached conclusion with CDB for
Sorry,
the
I
time.
can't hear you, Mr. Singh.
I said they had failed to reach conclusion with CDB up to that point in time.
Yes, but do I
But is that
understand your...
because of lack of capacity? I think that's the question.
Well, Mr. Chair, it was basically Ms. Mahato, then there was Ms. Dorothy Kobe, and I think there were two others at that point in time that made up the full debt capital markets team at the time. And Ms. Kobe was relatively new, I think, at the time. Ms. Mahato was relatively new in her position of group treasurer. I think she was just appointed, I think, 9 months before that, if I recall. I don't recall correctly. And she had not run a corporate treasury before. So that was the context within which the funding or the funding plan of Transnet was being executed at the time, together with the fact that we had to demonstrate to S&P the fact that we had an adequate A and B ratio, as I explained.
So the short answer is that you're saying there was no capacity at Transnet's treasury.
In my view at the
What
time,
it amounts to.
in my view at the time, Mr. Chair, Transnet Treasury had the ability to take care of the normal, mundane, and day-to-day activities that related to funding. In terms of this particular funding facility for the locomotives, it was a significant amount. We needed to raise 50 billion rand for the locomotive. It was not a small amount. The local debt capital market probably would have been able to do it over a period of time. But in order for us to be able to deal with the A and B ratio that S&P had asked us to comply with, there needed to be urgency relating to the fact that we needed to conclude contracts. The contract with US Exim and I think there was one additional one, I can't remember right now. I think it was Canadian Exim, or I think it's in my affidavit, Mr. Chair. But there were two additional contracts that we had been negotiating, which also were behind schedule in terms of being able to be concluded. And the fact that those two agreements were not concluded in time, there were certain penalties that we incurred. When we say penalties, it was not physical penalties that we had to then pay 10 million rand, for example, but in terms of higher cost of debt, in terms of being able to miss the appropriate timing of the market. So, Mr. Chair, in terms of this, yes, the Transnet Treasury had capacity, the Transnet Treasury was there, the Transnet Treasury could do all of this, but at the end of the day, it needed to be done within a time frame, within the context of the requirements of credit rating agencies, given the fact that we had an exposure of 50 billion that needed to be met.
So Transnet Treasury did have the capacity, but it was thought that they would not be able to do it within the time that it was required to be done.
Mr. Chair, I think the context is the Transnet Treasury had the capacity to take care of the day-to-day funding that was required.
Yeah.
This was over and above the day-to-day funding, albeit that it formed part of the funding plan.
So they didn't have capacity to deal with this type of matter.
Mr. Chair, they did, Mr. Chair, they did conclude transactions with other development financial institutions. AFD, KFW, all of these people are development financial institutions. We had not concluded that a transaction with China Development Bank before. Now, in terms of dealing with funders, if you dealt with them before, Mr. Chair, it's quite easy to conclude a transaction with them because you know what their pain points are. They've already dealt with you. They have already understood you. I think this was the first time that actually China Development Bank was making an investment into South Africa. So there was a significant amount of, how can I say, groundwork that needed to be done to be able to make them understand the South African market, firstly, and what they were getting into, and secondly, what our expectations were and what our alternatives were. Let's put it that way. Because I think one of the things that we found with China Development Bank was that they believed that we had no other alternative other than to come to them for funding. And this was one of the issues that we needed to get across to them, was that, yes, we need your funding, but understand that we actually do have alternatives.
Mr. Maybeck?
Yes, thank you. Perhaps just dealing with or evidence about the size of the team. Could I ask you, please, to go to page 4, MEM4, and have a look at paragraph 7.
MEM4.
No, it's in the same affidavit, it's at page 4.
Yes.
Paragraph 7. The Treasury team, are you there?
Yes, sir.
Had a complement of about 40 staff members, i.e. 32 professionals supported by 8 administrative staff. Professional staff in Treasury had multidisciplinary skills, competencies, and experience. This included mathematicians, accountants, investment bankers, commercial lawyers, traders, financiers, and economists who were all highly experienced with an average 10 to 30 years of experience in their respective fields. You want to comment on that?
Yes, Mr. Chair. But Ms. Mahato fails to actually say how many people of those 32 professionals were actually involved in the middle office in terms of fundraising activity. As far as I can recall, Mr. Chair, I don't think there were more than 4 or 6 people in the debt capital market structure at that time. But I do stand correction because it's a long time, but I do recall that it was not many people.
Then have a look at paragraph 13 at page 5. In the months following my appointment as head of structured finance, I capacitated my area by appointing 2 professionals and later added 2 additional resources. Paragraph 14, in addition, more professionals were appointed to the Treasury team, including professionals in Treasury operations to handle complex financial accounting matters, a forex trader, and additional cash and debt management professional.
So paragraph 14 actually has nothing to do with fundraising or capital raising. Paragraph 13 is more appropriate. As you can see, when she was appointed head of structured finance, she basically appointed, let's say, 4 people.
Nice. Perhaps we could just go back to 241. In the middle of the paragraph, under the heading Overall Governance, it says, when we negotiate and enter into agreement with lenders and investigators, we make certain undertakings and covenants that should apply to future facilities as well. The fact that Transnet's biggest ever transaction is negotiated and decided by outsiders, in brackets regiments, is a cause for concern as it exposes the company to undue risk. When we negotiate a facility of this magnitude, we assemble a multidisciplinary team that includes legal, tax, accounting, structured finance, and risk management team members. This is to ensure that all potential risks relating to the facility are identified and mitigated to the extent possible. You want to comment on that?
Well, Mr. Chair, firstly, when Ms. Makhato refers to the fact that Transnet's biggest ever transaction is negotiated and decided by outsiders, I would assume she's talking about local transaction, or is she talking about this funding facility?
Well, you'd be better placed than me, Mr. Singh. You responded to this memo.
Mr. Chair, if she's, well, in both cases, Mr. Chair, whether she's referring to the CDB funding facility or whether she's referring to the Locomotive transactions where they also played a role as transaction advisor, Mr. Chair, they did not negotiate. At the end of the day, ultimately, the advice comes from transaction advice. What we as Transnet management decide to do with it is up to us. They will always advise. We will basically agree with some advice. We will disagree with some. But whatever we believe that is in the best interest of Transnet, we will then engage with either the OEM or whether it was CDB. In this case, Mr. Chair, when she says that the facility of this magnitude, we assemble a multidisciplinary team of legal, tax, accounting, structured finance, and risk management. Mr. Chair, there was no difference when we concluded the China Development Bank transaction. All of these different legal, tax, accounting, structured finance, and risk management teams were all included. You will see later on, Mr. Chair, when we actually, maybe if we get there, you will see there were certain proposals that were made that were recommended by regiments together with JP Morgan that were rejected. And they were rejected particularly for the adverse accounting consequences that it may have for Transnet. You would recall yesterday when we read an email from Mr. Danny Smith in terms of the transaction advisory stream that they were advising on. And you will recall, Mr. Chair, that Mr. Smith said that Mr. Pillay had provided significant insight into options. Now, these are options that we would consider in terms of dealing with the foreign exchange risk relating to the locomotive contracts. But those option opportunities, let's call it the option opportunity that was proposed by Mr. Pillay, was not considered. And was not considered because, again, of the adverse tax and accounting implications that it would have on Transnet. So notwithstanding the fact that regiments was involved, it did not take away any of the other processes, or it did not override any of the other, how can I say, normal internal processes that would happen. What regiments would bring to the table? They would bring options. When I say options, now, these are not the financial instrument options, but they would bring different thinking or different alternatives, let's say alternatives to the table. It was then up to us to decide whether those alternatives were appropriate or not, were good or bad or indifferent. And that is what then would go to each one of these legal people, tax people, accounting people, structured finance people, risk management people, to engage, to understand whether this thing that is being proposed, is it good, bad, or indifferent?
So we then go back to page 33 of the memorandum, sorry, of the affidavit. We see at page
So page 33.
33, MEM 33, we see at paragraph 135 that you then wrote a responding memorandum, correct?
Page 130.
135, paragraph 135 at page 33.
So this is,
Anoj Singh wrote a memorandum in response.
yeah, but I'm trying to understand whether this memorandum is in response to the email or is it in response to another memorandum?
It's in response, it seems, to the email.
No, I don't think so, sir.
All right. Well, let's go to your memorandum that you find at, well, let's perhaps, if, insofar as it's important, at 133, Ms. Makhato says that she sent an email to you, and
So this is the one I assume we just
Yes.
looked at, correct?
that's the one we've looked at.
Yes.
All right. And then she goes on to say, however, regiments recommended that Transnet should proceed with the transaction, etc. And then at 135, she says, Mr. Singh wrote a memorandum attached as Annexure MM33 in response to the concerns that I had raised.
Okay, that's
Okay.
correct.
So I want to take you to 285. That's where you'll find your memorandum.
So it's MM36, right?
Yes.
Page?
285. You signed this on at 287. Is that 21 August?
It's probably 27.
20?
7,
27 August 2014?
looks like.
Is that right?
That is correct.
All right. So at 285, you see China Development Bank Locomotive funding response. And ultimately, at 287, you seek this recommendation. 5, it's recommended that the Group Chief Executive approve the response to the Group Treasurer for issues raised on the USD 2.5 billion loan facility with China Development Bank. So what you were asking really was that Mr. Molefe should prefer your response over Ms. Makhato's email.
No, I don't think that was the purpose of the memo. The purpose of the memo was to, as you would have seen in terms of the email correspondence and the communication, Ms. Makhato had a tendency of actually not coming through my office, but going directly to Mr. Molefe because of a relationship she had with Mr. Molefe from National Treasury. So the purpose of this email was to actually not have this he said, she said, but to get to a point where if Mr. Molefe believed that she was correct, he needed to say it.
Yeah.
If he believed I was correct, he needed to say it.
I think we're saying the same thing.
Yes.
Yeah. All right. It was to resolve the impasse one way or the other.
Yeah.
So you didn't feel comfortable taking the decision yourself. I mean, you accepted it was contentious.
No, it was not contentious. This was a mechanism to deal with the let's call it, for want of a better word, the HR issue.
And Mr. Molefe then didn't do what, what you wanted.
Yes, sir, evidently.
Correct.
I think he noted, yes.
To take you to page 285.
That's 2.
285.
Oh, just the previous page.
You talk about regiments, paragraph 3A. Regiments capital was appointed as transaction advisors. In terms of the aforementioned mandate, Regiments Capital was required to advise on deal structuring, financing and funding options to minimize risk for Transnet. Correct? We've seen that.
Yes.
Accordingly, the negotiation with CDB to successfully conclude a ZAR funding facility at a ZAR cost not exceeding 9.3% for a tenor not less than 15 years at no additional fee is part of their mandate. Is that correct?
Yes.
So this was part of their original mandate?
Yes, based on this memo.
Yes. And you say this as at August 2014?
Yes.
Then if I could take you back, please, to page 34. So now, by this time, Ms. Makgatho at 136 has mentioned that Mr. Molefe wrote noted on your memo.
We now at one? Yes.
She says at 137, at page 34, on August 2014, I drafted an internal memorandum to the board seeking approval for funding initiatives subject to acceptable terms and conditions. And then she goes on to say at 138, I later discovered that Anoj Singh had replaced the Treasury Board memo with a PowerPoint presentation that was based on the flawed regiments analysis. So it seems that this junction between the two of you continued.
Yes, sir.
And then, just to complete the chronology, at paragraph 140, at page 35, it says, pursuant to Anoj Singh's representation to the board, the attached CBD term facility agreement was signed on 4 June 2015, committing Transnet to, as she says, a very expensive loan agreement. But leaving that aside, you accept that the agreement was concluded on the 4th of June 2015.
I don't recall the date, but I can confirm that we did conclude a term facility agreement with China Development Bank.
Perhaps I could take you, in conclusion of this, to Mr. Mohammedi's evidence. So if I could just have a second, Chair, please. I think I've seemingly mislaid one of my files. But I'm going to have to come back to that perhaps after the adjournment. Perhaps what I can do is I'm going to take you to his affidavit when I find mine. But let me just quote to you what he said in evidence from the transcript. He, in his evidence, concluding that the terms of the CED loan made no commercial sense to him. he testified that, and this is a quote, the only possible plausible explanation from my perspective would be that there was an agenda for payment to be made to regiments, ultimately, or some entity that existed outside of the system. He said that on day 93 at page 144 of the transcript. Do you want me to read that again? It says the only possible plausible explanation from my perspective would be that there was an agenda for payment to be made to regiments, ultimately, or some entity that existed outside of the system. Want to comment on that?
Yes, Mr. Chair. Firstly, Mr. Chair, I don't think Mr. Mohammadi is competent to make that assessment. I don't think he's actually been involved in a loan negotiation in his professional career that would require a facility of $2.5 billion from Chinese investors. And I say that very particularly because investors are finicky about what they want. So when you deal with US investors, there's a particular format in which they want loan agreements to be. There are certain formats in which there are certain terms and conditions that they will accept. There are certain terms and conditions that they won't accept. When we dealt with the Chinese, there were certain terms and conditions that they would accept. There were certain terms and conditions that they would not accept. And Mr. Chair, in terms of the CDB loan facility that was concluded, Mr. Chair, if I do have an opportunity at the tea break, I will reference my affidavit. There is attached thereto a document that effectively outlines the benefits associated with the China Development Bank loan facility that I think will go a long way to put Mr. Mohammadi's concerns at ease.
See, the other thing that Mr. Mohammadi said, and I think that's in the affidavit, which I for some reason can't locate, is he echoed Ms. Makgatho's position, and that he felt that Treasury would have been able to do this job.
Well, Mr. Chair, again, with hindsight, it's perfect science to be able to say, yes, I think they would have been able to do it. Mr. Mohammadi was part of the group finance team at the time. He was part of the Locomotive acquisition process. And had he had the foresight to say that, the Treasury team could have done it at the time, he should have raised his concerns at the time with me, but he did not.
I want to finish off Ms. Makgatho's affidavit by taking you to something different. Could you please turn to page 19?
19. So it's
19?
MM 19.
Yeah, MEM 19. This is something that I dealt with Mr. Molefe. I'd like to just deal with it now from 71 to 76, not very long. She talks about the fact at 71, about 5 lines down, on that day, and that would have been in about the third quarter of 2015, Anoj Singh gave me a funding proposal from regiments in hard copy and informed me that it was a very important matter that Brian Molefe needed executed speedily. He said that I should excuse myself from attending FinCo and CAPIC and rather spend the day working on this urgent proposal and draft a memo recommending the proposal for his signature and approval by Brian Molefe. Could you comment on that?
Mr. Chair, I don't recall the specific event in terms of being able to provide this proposal to Ms. Makgatho. I did receive proposals from regiments, from APSA, from all the banks regularly. And the first thing that I would do, Mr. Chair, is take the proposals and provide it to Treasury and say, we've received this thing, please review it and let us know what you think of it. So it was a matter of course.
Well, what this reflects is that what was required of her was to draft a memo recommending the proposal. for Mr. Malefe's signature and approval?
Mr. Chair, it's unlike me to basically say to anyone to take something and draft a memo on the basis that it's not reviewed or understand the implications thereof on Transnet.
Well, that I think is the issue. Because she says you did do that.
I deny it,
You deny it.
yes.
At 72, she says the regiment's proposal was that regiments will facilitate a 5-year, 5 billion rand loan facility that was to be funded by Nedbank. You recall that?
Mr. Chair, as I said, I don't recall specifically this regiment's proposal, but as I said, the reason maybe is because I received proposals almost weekly from banks, if not more frequently than that.
Yes, but just to retrace the steps, it's not a matter of simply receiving a proposal. On her version, she says that you wanted her to cancel all of her meetings and spend the day working on an urgent proposal and draft memo recommending the proposal.
As I said, this would not be something that I would have proposed to Ms. Maha.
Then at 73, she says that the proposed facility was priced much higher than normal facilities or smaller loan facilities or domestic bonds. My calculation indicated that Transnet would have to pay an additional 150 million per annum in interest payments over and above what Transnet normally pays for similar facilities. This translated into potential losses of 750 million over a 5-year period. I shared my analysis with Anoj Singh and indicated that I did not recommend the proposal given potential excessive costs in interest payments. He responded saying that it is an instruction from Brian Malefe and that I should quickly complete the memorandum for approval the same day. Comment on that?
Mr. Chair, as I said, I don't recall this, and this is not something that I would have instructed Ms. Mahato to do in any way, shape, or form.
At 74, I felt very uncomfortable with the same-day approval request, as we had never rushed funding initiatives before and definitely not same day, especially given the potential losses of 750 million over a 5-year period. She goes on to say at 75, I decided to discuss the matter directly with Brian Malefe and went to his office. I told him that I understand that he expects me to urgently recommend a 5 billion rand 5-year loan that Regiments is proposing, wherein 150 million would be unnecessarily incurred per annum, accumulating to 750 million over a 5-year period with no clear benefits for Transnet. I was irate at that time that I explicitly told him that should we approve the structure, we will go to jail for stealing money as we are the custodians of Transnet's funds. And then this piece concludes, the structure was overpriced, we had a direct relationship with Nedbank, there was no need to use a conduit like Regiments to engage with Nedbank. Brian Malefe agreed with me and said that he will handle the matter. The structure was never implemented. Do you have any comment on that?
Mr. Chair, I don't recall Mr. Molefe ever engaging me on this matter, to the best of my knowledge. This was never discussed between Brian and myself. Mr. Chair, if this was actually something that was faced in reality, my response to this issue would have been to Ms. Mahato to engage with Nedbank to understand why was Nedbank, as she says, we had a direct relationship with Nedbank. Why would it be necessary for Nedbank to engage with us via Regiment? So that would be something that I would have raised with her at the time. Given that this was which seems like a relatively vanilla funding facility. There was nothing extraordinary about this, except that they were providing money to us. So there was no need for regiments to be involved in this in any way, shape, or form.
I'd like to turn now to a different topic. Chairperson, I don't know if this would be a convenient time to take tea.
Yeah, maybe it would be. Let's take the tea adjournment. It will be 15 minutes. And we adjourn.
Yes.
I will just wait for Mr. Chair to get his document.
That's Annexure AS4, is it?
That is Annexure AS4, that's correct.
Please go ahead.
Thank you, sir. Mr. Chair, you will recall that Mr. Myberg led some evidence relating to Mr. Mohammadi's comments. And
Yes.
I responded by saying that there is a document that outlines the benefits relating to the China Development Bank loan. And this document, Mr. Chair, purports to record that in terms of the value that was added through the regiment's interactions with China Development Bank. Mr. Chair, if you look at 1557, you will see that this is a summary of the value added from negotiation support provided by regiments. A 15-year amortizing profile was negotiated as opposed to CDB's proposed 10-year amortizing profile. The longer profile duration provides a better asset management liability match. So, Mr. Chair, basically what this means is that China Development Bank had offered a 10-year facility, meaning that you would repay the loan in 10 years. But we insisted through regiment's interactions with China Development Bank that it actually suits Transnet better if we have a 15-year facility, in that the locomotives actually are long-term assets, because it takes 3 years for them to basically be built and come into production. So if you give us a 10-year loan, we basically only have 7 years to repay this loan. It then becomes quite expensive. So the longer the duration of the loan, the better revenue generation and repayment of the loan. So you have better matching of the revenue generation of the asset, so you generate the revenue from the asset and then have the ability to pay the loan. The capital grace period was extended from 36 to 54 months. And again, Mr. Chair, in terms of the capital grace period, this is basically a grace period between which you actually draw down the facility. So let's say you take the money today, but the grace period then enables you a period of 54 months within which to then make your first payment. So you're actually allowing the entire period during which the locomotives are being built to actually not pay anything on the loan. The CDB initial pricing was 300
Of
basis.
course, I take it, although you are not paying, the interest is being added on.
Well, you'll have to accrue the interest, Mr. Chair, because you've got the benefit for the facility. You've actually taken the money, except that you're not repaying capital because the locos are not yet generating any revenue. CDB's pricing, Mr. Chair, now pricing is the actual cost of the facility. You will see it was originally 300 basis points, and it ended up being 257 basis points. Which is a 43 basis point saving. Then, Mr. Chair, as you can see, the fourth bullet point, in order for us to have an appropriate level of interest cost relating to the locomotives, because the locomotives was a significant chunk of the capital. If you recall, we said that we had a capital spend of 300 billion. The locos was 50 billion of that. Now, that's a significant portion of the entire, it's almost 20% of the entire capital spend that we're going to do. So if you locked yourself into a very expensive facility for 20% of the facility of the capital, it will be a burden on the interest line for quite a significant amount of time. So in order to actually get to a point where we had an acceptable level of interest cost, we actually decided to do a blended facility, which is a dollar facility as well as a rand facility. Mr. Chair, you have to accept, it is just economics, that when you borrow in South African rand, it is cheaper. When you borrow in US dollar, it is more expensive. And it is just because of the currency. And obviously other factors, but the biggest point is that, simply put, it's just currency. So each time you borrow overseas, it's actually more expensive than borrowing local. So in order to manage that appropriately, you had to have a blend of rand financing as well as dollar or any other currency financing. Then, Mr. Chair, if you go into the next page, you'll see that we actually had other interactions that we've also achieved. That's on page 1558. So these are relatively technical details, Mr. Chair, but basically, in terms of the change of the reference rate, so Mr. Chair, the reference rate means that the cost of the debt or the interest cost, you could either do that quarterly or biannually or annually. And depending on which one you choose, ultimately, the amount of debt that the amount of interest that you actually pay over the life of the loan is different. So in changing the reference rate from, let's say, annually to semi-annually or quarterly, there's either a saving or there's a cost involved in. So that was identified and captured. Sensitivity in executing the CCS. Now the CCS stands for a cross-currency swap or a contingent cross-currency swap in this case. This was executed with JP Morgan and it resulted in a saving of a further 112 basis points. But in executing strategy, Mr. Chair, in terms of the contingent cross-currency swap with JP Morgan was changed. And that was the reason why we actually had gone to the ADC, if you recall on that memo, to request the ADC to confine the CCDS to JP Morgan. Because what we actually found, that is, if we go to the market and say to the market, now the market is, if you're executing a swap, you have to execute it with a counterparty. Now the counterparty can only be the banks. Now, as soon as you approach the banks, to say to them, give me a quote, they already know that a transaction is coming. Well, why else would you ask them for a quote? Right? And the way that you ask them, the way you test the market is you ask a number of banks. But as soon as you ask a number of banks, what happens? All of them know a transaction is coming. And automatically the price for that instrument immediately goes up by 10 to 15 basis points. So in order to prevent that, what we call front running of the transaction, because of the size of this transaction, those 10 or 15 basis points actually add up to quite a lot of money. So what was decided in this transaction was to say, let us test JP Morgan's pricing. If we are comfortable with JP Morgan's pricing, there's no need for us to go and test the market in executing. So we'd actually just execute with JP Morgan alone and not run the risk of adding 10 to 15 basis points on the transaction relating to the front-running risk. The other, I will move to the other two items on page 1558 I will skip, as well as the two items on page 1559 I will skip in the interest of time, Mr. Chair. But it's the affidavits on record, the annex J is on record, Mr. Chair.
Yes.
The last one that I would like to actually comment on is the last thing on page 15, or the last item on page 1559, which relates to the standby facility. Now, Mr. Chair, of all of these things that I've mentioned to you, me as CFO, actually this standby facility was actually the most important thing that came out of this entire thing. Because as I said to you originally, the reason why we actually opted for regiments to partner with Transnet Treasury to negotiate the facility with China Development Bank was actually for us to satisfy what we called the requirements of S&P in relation to the A and B ratio. Now, having signed a facility with China Development Bank of $2.5 billion, if you go into the detail of the loan agreement, Mr. Chair, the facility was for $2.5 billion, but the commitment to draw down was only $1.5 billion, which meant there was $1 billion that China Development Bank had committed to us with no actual drawdown requirement. So that was as a facility that we could determine whether we required it in, I think, in 12 months or 18 months into the future. But the facility was there. So it was a commitment that China Development had given us in writing that we had $1 billion available to us at any given point in time. So that satisfied the requirement of S&P as a committed facility. So the $1 billion basically was there, enabling me to satisfy S&P's commitment in terms of the A and B ratio. So to me, Mr. Chair, this was one of the things that was really, really helpful in terms of being able to satisfy S&P requirements. So, Mr. Chair, this I submit as the benefits relating to the China Development Bank facility in response to Ms. Makhato's comments and criticism and Mr. Mohammadi's comments in relation thereto.
Thank you.
So you've, as I understand it, addressed the value that you say regiments added.
That is correct.
I think the essential controversy, though, is whether the internal treasury couldn't have added the same value.
Well, hence, Mr. Chair, I would then ask the question, where were all of these things that I just read out to you? There were none of these ideas that emanated from Transnet.
Yes. But of course you engaged, they didn't have the opportunity to do that, or do I get the chronology wrong? What happened is when Ms. Makhatho came back from travels in the middle of July, you had engaged Transnet, regiments.
No, Mr. Chair, you would recall that they had an opportunity to engage with CDB for a period of time.
All right.
When those engagements, in my view, were breaking down, that is when regiments was
That's when you
on board.
approached regiments.
That's when I approached
All right.
regiments. But even then, to Mr. Chair, I think I would like to clarify and make this point very clear, and I thought I had done it before, but I'll reiterate. There was no point in time that I can recall where regiments had exclusive and unfettered access to either locomotive manufacturers or China Development Bank. Regiments worked in concert with Transnet Treasury for all intents and purposes. They worked with the cross-functional evaluation team when they were doing the locomotive negotiations, together with Transnet Treasury and the engineers. So from that perspective, it was not as if regiments had this and they then went off and there was no one else with them. It was never the case. If they were dealing with China Development Bank, there was always a case that they would deal with China Development. Maybe they didn't have a Transnet person sitting with them every time they spoke to China Development Bank. But certainly when the feedback was given to Transnet, it was given to Transnet on the basis that it was given to me as well as Treasury. There was no way that these legal people, the tax people, the other people that Ms. Makhato mentions in her affidavit would have been able to engage with these matters if regiments was going off and doing their own thing without interaction with Transnet, individuals and staff.
And sorry, there's something that I forgot to mention to you, just reminded me. Ms. Makhatho alleges that you excluded her from the data room. It's something I didn't put to you. Do you want to comment on that?
Mr. Chair, again, I think Ms. Makhato does make that allegation. There was no occasion that I would have given an instruction like that for any reason. Ms. Makhato was, on her own version, a member of the cross-functional evaluation team. She had full access and rights to be in the data room and get access to any information she required. The data room was not under my control, Mr. Chair. As I mentioned in testimony yesterday, the entire evaluation process relating to the OEMs and the data room was actually at Transnet Freight Rail. It was not at corporate center. I had no oversight over that data room. It actually, oversight relied with Mr. Gama and Mr. Jan.
And then perhaps I could just ask you with reference to your slide, page 1559, you mentioned to the chairperson that you thought the advice in relation to the standby facility was particularly useful and valuable. Do I understand you correctly? 1559.
That is correct. I'm there.
And is that, that standby facility of $1 billion, correct me if I'm wrong, is that then what was dealt with by way of the ZAR club loan?
I would, this one and that one is not the same. Huh?
Are they different things?
They're different.
All right, thank you.
This is a standby facility. So if you needed it, you could have drawn down.
It wasn't another fundraising mechanism.
This one? No, this was, so if we, let's put it this way. If we needed this, there was no other agreement that you needed to sign. All you needed to send is a letter to CDB to say we are activating this facility and please provide us $1 billion.
And then I have now found, thankfully, my Mohammadi file, Exhibit BB3A. BB3A. And could you please turn to page MSM 18, 18. So, Mr. Singh, I've already put this to you, but just for the purpose of the record, MSM page 18, paragraph 5.5.9, Mr. Mohammadi states the Transnet Treasury team had sufficient expertise to enter into loan transactions without the need for external support. In my view, there was no need for the above-mentioned loan arrangement fee to be incurred. And he then makes certain other statements to that effect. Do you have anything to add to what you've already said? I think you've already told the chairperson that, firstly, you don't think that he has the expertise to proffer this view, and secondly, if my memory serves me correctly, you said that if he had that concern, he should have raised it at the time.
That's correct.
And is it your evidence that he didn't do that?
That is correct.
And then perhaps I could just take you to one aspect, some regulatory issues. In Exhibit BB 27, so that's the POI bundle.
I'll just do some housekeeping on it. I'm there, sir.
And I'd like to take you to page 395, part of the M&S Transaction Advisor Report. Paragraph 2.7.12, in the middle of the page, the report reads, the guideline on cost containment measures, the DOA framework of 1 September 2014 and the PPM October 2013, all make reference to the use of internal skills and resources before the procurement of external consultants. It is only in the event that there are no skills and resources internally that a public institute, such as Transnet, may then procure external consultants. Now, do I understand you to be saying that Transnet did not have these skills internally?
Mr. Chair, I think, as I've said, in my view, Transnet Treasury was not sufficiently capacitated at the time to meet the needs of the organization at the time. That's why we engaged with Regiment.
I appreciate that. And then, just for the sake of completeness, 2.7.13, further to the fact that Transnet is required to ensure that there are no internal skills and resources available to it before procuring external consultants, the Transnet DOA framework also places an obligation on Transnet employees stroke business units to, quote, always obtain on FX forward rates and liaise with Treasury trading desk that will verify the rates to ensure it is market related. The business units can only enter into the FX hedges with the supplier once the rates are accepted by the Treasury trading desk via email. Once the above approvals are obtained, the Treasury traders will sign off on the rate acceptance, close quote. Then at paragraph 2.7.14, the exclusion of Transnet Treasury in terms of the CDB facility was in contravention of the guidelines on cost containment measures and, which we've dealt with, and the DOA framework. The use of regimens should not have been approved without having obtained the Treasury traders sign off on the rate acceptance. You want to comment on that?
Mr. Chair, again, I think, as you would see in testimony that would follow, I think MNS takes elements of applicable legislation or procedures or policy out of context and uses it for their purpose to obtain a predetermined outcome, in my view. If you look at this particular DOA framework that they're actually referring to, Mr. Chair, and I'm not too sure if Mr. Chair would actually want to go to it. If you would like to, we can, because I think there is a delegation of authority framework attached in one of my affidavits. You will see, Mr. Chair, this delegation of authority framework that they refer to, and this issue of Transnet employees, Mr. Chair, and business units. This is saying that, remember, we have a centralized treasury, so there's a treasury department that does whatever they do and treasury activities. They are the only ones that are allowed to engage with banks, right? So what this is saying, it's saying employees other than these treasury employees, it makes reference to business units. Business units are all of the people outside treasury. So it will be Transnet Freight Rail, it will be Transnet National Port Authority, pipelines, and all of these other people. If they had to engage in a foreign transaction, if they had to engage with a supplier relating to a equipment that needs to be bought in dollars, what this says, they have no authority to commit Transnet to that particular rate that the supplier is offering without actually having reference to Transnet Treasury first. That's what the purpose of the delegation of authority framework, that is the purpose of why it is there. It's not this interpretation, Mr. Chair, that MNS applies to that provision of the delegation of authority framework is incorrect. And Mr. Chair, if you would like, we could go to that delegation of authority framework to look at that specific element.
So this comes from 2.7.12 and then goes up to 2.7.14.
So the one that I'm referring to, Mr. Chair, is 2.7.13.
Yeah.
If you look at the third line, it says...
Yeah, but let me go back to 12 first.
Yes.
The guideline on cost containment measures, the DOA framework of 1 September 2014 and the PPM October 2013 all make reference to the use of internal skills and resources before the procurement of external consultants, which all makes sense. It is only in the event that there are no skills and or resources internally that a public institute such as Transnet may then procure external consultants. I guess no problem there.
So, Mr. Chair, there I've given a response and said, in my view, we did not have the capacity to execute.
Okay. Then 13, further to the effect, Transnet is required to ensure that there are no internal skills and resources available to it before procuring external consultants. The Transnet DOA framework also places an obligation on Transnet employees stroke business units to always obtain quotes on FX. That's foreign exchange,
That's foreign exchange.
right? Forward rates and liaise with Treasury trading desk that will verify the rates to ensure it is market related. The business units can only enter into the FX hedges with the supplier once the rates are accepted by the Treasury trading desk via email. Once the above approvals are obtained, the Treasury traders will provide sign-off on the rate acceptance. And then 14, the exclusion of Transnet Treasury in terms of CBD facilities was in contravention of. So what is your contention of what this means? Obviously, you are saying MNS has misapplied or misinterpreted the delegation of authority.
They've quoted the delegation of authority in 2.7.13 correctly.
Correctly.
Correct. So that is what it says.
Yeah.
I can confirm that. In applying it in 2.7.14, they are incorrect.
The exclusion of Transnet Treasury in terms of CBD facility was in contravention of the guideline on cost containment measures and the DOA framework. The use of regiments should not have been approved without having obtained the Treasury traders sign off on the rate acceptance. Okay, just repeat what your point is, why you say they were wrong.
So, Mr. Chair, in terms of the, so they say the use of regiments should not have been approved without having obtained the Treasury traders sign off on the rate acceptance. So, Mr. Chair, in my view, they are dealing with two matters. Firstly, they are saying, and I don't know, they seem to be confused, the use of regiments should not have been approved. Okay, now I'm saying that the use of regiments should not have been approved, I'm assuming in terms of the cost containment measures, which I've given a response to. Without having obtained the Treasury traders sign off on the rates accepted. Now again, Mr. Chair, as I've said to you, the regiments does not have the ability to approach the market. They have the ability to go and look at their screens and do whatever they do on Bloomberg because everyone has access to Bloomberg. But at the end of the day, it still comes back to the Transnet trading desk that has to issue the instruction to JP Morgan to say, please place this instrument in the market. JP Morgan will never issue an instruction on regiment. They will never accept an instruction from regiment. They have to accept an instruction from Transnet. And the only people that they would accept that instruction from is the trader. They wouldn't even accept the instruction from me, being the CFO, because I'm not the delegated counterparty to issue that instruction. So from that perspective, Mr. Chair, that for all appropriate times, the traders would have had to be involved in issuing the instruction to execute the hedge or execute the instrument.
Yes. So are you saying that although regiments was involved, ultimately there was no breach because before anything could happen, they would have to go back to Treasury?
Treasury was the only approved counterparty to engage, they were the approved counterparty with banks to basically issue instruments. And this paragraph that they've quoted, Mr. Chair, of 2.7.13, as I said, relates to business units, not to Treasury itself. Because remember, this instrument was being issued not on behalf of Transnet Freight Rail. There's no Transnet Freight Rail. Transnet Freight Rail is not a legal entity. Transnet was a legal entity. This loan was entered into between Transnet, the legal entity, and China Development Bank. Transnet Treasury would then be the authorized entity to enter into a cross-currency swap with a counterpart, which was JP Morgan in this case.
Mr. Maybeck?
Yes, thank you, Chairperson. So I want to deal now with another topic, and that is McKinsey Regiment's consultancy contracts on confinement, 4 in 4 days. So far we've been dealing with the 1064 transaction advisors contract and fundraising. There were other parts of the fundraising that you were not involved in, which occurred in the time of Mr. Garma, principally the ZAR club loan. Can I take you please to bundle 5B, page 499. Mr. Singh, sorry, it's your exhibit.
Oh, sorry.
5B.
This is a face.
$499.
Sorry, which page?
Yes,
Mr.
Chairperson.
Master.
What page, sir?
499. If I can direct your attention, please. So this is a part of one of the money flow reports at 499. Just direct your attention to paragraph 44, 5, and 6. You'll see at 44, 31 March 2014, Transnet decides to award the coal line contract. March 2014, Transnet decides to award the coal line contract to McKinsey and Regiments on a confinement basis without competitive bidding. Then 1 April 2014, the next day, Transnet decides to award the Kumba Iron Ore contract to McKinsey and Regiments on a confinement basis without competitive bidding. And then paragraph 46, on 3 April 2014, Transnet decides to award the manganese contract and the NMPP contract to McKinsey and Regiments on confinement without competitive bidding. Do you see that? So there are the 4 contracts in 4 days. You see that?
That.
So you accept that happened?
I recall that these contracts were,
Yes.
or these confinements did occur.
We'll come
The dates-
we'll come to some of them in a moment.
The dates I'm not too sure of, but I do confirm that they did occur.
I just want to take you, and it's something that we touched on yesterday. Could I ask you please to go to page 716,
Of the same file?
same bundle, 716, so annexure to this report. What you see at 716, perhaps you could keep your finger there and then turn back to page 700.
So I
You'll
keep
see.
my finger here and go back.
So you'll see at 700 that this is a bid submitted in respect of the coal line. You see that?
That is correct.
But if you go forward to 716, this was a bid submitted by McKinsey and Regiments Capital jointly. And 716 says, we, that being Regiments Capital, will subcontract consultants and services from a company advisory, Homex and Albertine, and provide them with skills development opportunity. You see that?
That is correct.
So when I mentioned to you that What happened in respect of these contracts is that regiments actually used Homex and Albertine as supply development partners. Do you see that?
That is correct.
And these are the two main, or amongst the two main money laundering entities. You see that?
I see that, sir.
Did you ever read this bid?
Mr. Chair, as I explained previously, Mr. Chair, these, the confinements that Mr. Myberg referred to would be prepared by procurement based on the facts that's given by business. If they believe that the confinement rules apply in the business circumstances, they would then prepare the necessary confinement documentation that would then be approved and submitted through to myself and ultimately to be approved by Mr. Molefe. Once those documents are then approved, Mr. Chair, the confinement document is approved, it goes back to procurement. Procurement then basically sends out a request for proposal, a formal document. That formal document would then set out the business requirements and what is required from the potential service provider or the potential service providers. A cross-functional team would then sit, before that, the RFP would then set out the return date and all of those requirements that needs to be fulfilled. The cross-function evaluation team will be identified and they would sit and receive the bid or bids, as the case may be, and they will evaluate that bid against the business requirements that were issued in the RFP and the evaluation criteria that was set out. This particular document, Mr. Chair, would go to the procurement team or the evaluation team that would then evaluate that. I would not necessarily ordinarily receive an RFP document like that.
When you say not necessarily, what do you mean by that?
I have never, well, in this particular document, I did not receive.
All right. Well, let's go to just one other example. Go to page 721. Here you will see that it's the bid for the NMPP. Do you see that?
Yes.
And if you go forward then to page 732, you see the same text in respect of regiments. 732, third bullet point, your subcontract consultants and services from companies such as the Company Advisory, Homex and Albertine, and provide them with skills development opportunities. See that?
That is correct.
Could I ask you please to turn back then to page 500? Says there at paragraph 49, McKinsey and regiments prepare bids. We've gone through these. Coal line, Kumba iron ore, manganese and NMPP contracts with Transnet. Regiments indicates they will be using Albertine and Homex as its supply development partners. Albertine is Mudli's company. Homex is a Gupta laundering vehicle, which is ultimately paid more than 100 million of the value regiments receives under these contracts. See that?
That is correct, sir. Mr. Chair, I think it's also appropriate to probably comment in terms of the evidence of Mr. Fine in response to this, I think did allude to the fact that I'm not sure if they actually did, McKinsey did reference checks or actually vetted Albertine and Homex in any way or form before allowing them to be supply development partners of McKinsey.
Just so that I understand, and perhaps you must correct me if I'm wrong, in relation to these four contracts, this is not regiments being McKinsey's supply development partner. It seems that they bid jointly in a partnership effectively?
I don't think so. I think this was where they still were supply development partners to Regiment.
All right, so you understood the structure to be that Regiments was still, and I can have a look at that, was still McKinsey's supply development partner, and then Regiments itself had its supply development partners, as we've seen.
Or subcontracted a portion of the work to,
All right.
to whoever they needed to do it.
Could I now take you, please, for the first time, to Exhibit BB 2.1A?
Give me a second, so let me just do some.
And then could I ask you, please, to turn to page PSV 62.
There's lots of notes and stuff in this one, so I'm not too sure.
So I don't know about that.
Seems like a working.
Chairperson, can we just get a bit of clarification exactly what this relates to? So, because we're sitting with electronic versions that we're trying to
It relates
find
to
our
these,
place.
it relates to these contracts.
Okay.
What contract?
The ones that we're just talking about now, the 4 on 4 days.
Yeah, this is Mr. Peter Volming's statement. I think that's what you're looking for.
So page 62, and I'm going to ask you to comment, I think, on 3 things, Mr. Singh.
Page 62, Exhibit BB 2.1A, if that helps you.
We don't have those bundles. Maybe if my learned friend can refer to a specific person, because I know we were given, as an example, affidavits, and we've saved it in that regard.
So it's Mr. Volming, Peter Volming. All right, now what Mr. Volming says at page PSV 62, paragraph 138. Are you there, Mr. Singh?
138, I am.
Yeah. So he talks about over a period of 4 days, the previous GCE approved 4 confinements, and he sets them out. And at 139, he says, although each of the transactions viewed separately fell within the DOA for confinement given to the GCE up to 250 million, the combined value of the transactions fell within the DOA of the BADC at the time, up to but not exceeding $1 billion. He then states that given the fact that the transactions related to the same or similar services and were awarded to one firm within a few days of each other, Transnet effectively awarded one package of projects to McKinsey, valued at 619 million, that ought to have been taken to the ADC for confinement purposes. The applicable provision of the PPM warned against the practice of parceling. Under the heading Prohibited Practices, PPM 14.2.3 states the following, quote, when the full scope of work is known at a point in time, requirements may not be deliberately split into parts or items of lesser value in order to keep the transaction value within a particular delegation of authority level, or to keep it below the threshold of an AC or a person with higher delegation of authority, this is considered to be parceling and will be regarded in a serious light as it amounts to non-compliance with procedural requirements. And then he ends by stating that on the face of it, the splitting of the transactions amounted to a breach of the rules against parceling. I just give you an opportunity to comment on that.
Mr. Chair, firstly, in terms of our 10.6 response that we were required to respond to Mr. Volming's statement, we were not required to respond to this allegation that he makes. But in the interest of time and for us to move forward with this, Mr. Chair, I'm not completely familiar with the rules of parceling in terms of the PPM, as it's basically outlined here in terms of paragraph 14.2.3 of the PPM. But what I can say, Mr. Chair, is that, and I'm not an expert at procurement, and as I said before, these confinement documents would have served before procurement. Procurement would have probably been the people that actually prepared the document. I would assume that having it gone to Mr. Molefe and myself in terms of value, it would have been approved by at least Mr. Peter. I don't recall if he did or he didn't, but if we have the submission documents, we can confirm that. And Mr. Chair, in my view, I would suggest that this does not amount to parceling in that it may have been services that were provided by one firm, but the skill set that was required and the service that was required in each of these items were significantly and distinctly different. So if you take, for example, the NMPP contract. The NMPP contract, Mr. Chair, was a de-risking of a capital project. So it basically says capital project is in trouble. It's like a Medupi and Kusile. Its costs are going from, it started at 9, it was at that time, I think, 25, 26 billion. And we were behind schedule, and the costs were continuing to escalate. So the nature of that project, Mr. Chair, was basically to rescue the project and required very different skills compared to, let's say, a manganese construction contract. Now, the manganese construction contracts, Mr. Chair, as you will remember, when we were giving evidence regarding Mr. Bester, that contract, the manganese project, let's call it the manganese project, as it relates to McKinsey here, was advice on a contract that was still to be entered into to prevent what we had seen on the NMPP to recur. So again, it was very different deliverables. It was distinct deliverables. The iron ore contract, Mr. Chair, again, was a 20-year, if not 50-year contract, if not an evergreen contract that we had, I think, with Kumba Iron Ore and Asmang at the time, with an attempt to renegotiate that contract, to be able to get a higher revenue stream out of that contract for Transnet. So in that case, Mr. Chair, that was again a very different set of skills that was required. You needed to understand the iron ore industry, you needed to understand the capital requirements of a mine, you needed to understand the capital requirements of Transnet in terms of the iron ore line specifically. So it was very different skills. In terms of the coal line contract, Mr. Chair, that was also a very distinctly unique, different deliverable. In terms of the coal line contract, we needed to unlock the bottlenecks that the coal line was experiencing. And unlocking the bottlenecks meant that if we were doing, let's say, 75 million tons of coal through the iron ore line per annum, we needed to identify the bottlenecks, debottleneck the line to enable us to move from 77 to 70, from 75 million tons to 77 million tons per annum. So in my view, Mr. Chair, the distinct nature of each of the deliverables, in my view, does not allow it to be classified as parceling, albeit that it was probably issued to McKinsey as one firm. If we issued this out on open tender, Mr. Chair, it would have went to 3 or 4 different firms because of the different skill sets that are required to actually achieve the outcomes that we require.
There's two other things that I just...
I wonder whether the the test to establish whether a set of transactions, separate kind of transactions, constitute parceling would be whether there would be any problem if they were given to different bidders. Could they be done by different bidders?
So I don't know if you finished.
As I understand
Yes.
parceling, and you'll tell me if I've misunderstood it, it's when one transaction is split up into different kind of transactions in codes in order to circumvent a certain limit on delegation of authority. Okay. Now that obviously maybe would be easier to see if you have one transaction, maybe that has different components, so it could be given to one person in one go, but you decide to give it to the same entity as if it's different transactions, but actually it can be different components of the same thing.
Mr. Chair, I think, well, I'm not too sure what you're asking. I followed you up to...
I'm just thinking if you, instead of saying, I'm giving Mr. Singh this contract to build a bicycle.
Yes.
Okay. Instead of saying that, I say I'm giving Mr. Singh a contract to do a certain part of, or certain part or parts of the bicycle today. In a month's time, I give him a contract to do another part or other parts of a bicycle. That must be parceling, or would it not be?
I think, Mr. Chair, maybe let's use this.
It's like splitting.
It's like splitting, but maybe let's use this example. Let's say Transnet has a requirement for 1,000 books. Okay, so the buyer knows he requires 1,000 books, but he then says, okay, I place an order for 250 books in week 1. I put another order in week 2, another week in 3, another one in 4 to the same supplier.
Yeah.
But knowing that the 1,000 books would need to go to, let's say, the GCE for approval, but the 250 books can be approved by himself. So, crudely put, that is what parceling means.
Basically splitting
Something that would be identical.
That should be one transaction.
That should be, yeah, but also it should be relatively identical to something that you would get.
Yeah.
So you can't say, let's say he had a requirement for 1,000 books, right? But black books. And then he needed 250 blue books. So when he places the order for 250 blue books, it's not necessarily that he's then splitting the order from 1,000 black books. So there has to be some link.
So you say there must be some identity.
In my understanding, Mr. Chair, as I said,
yeah.
I'm not just expert in this aspect of the PPM or the PPM in general, but I'm saying there has to be some similarity for you to link.
And you say here because one is coal, another one is iron ore, another one is manganese, and so on. You say it can't be.
Well, not by just the nature of coal, iron ore, manganese, and NMPP. I'm saying it could have been NMPP for all of them, but the nature of the output was significantly different. And the skill set that was required was significantly different. Mr. Chair, let's say, for example, if we sent the coal contract or the coal confinement to Mr. Molefe, he may have said no. He said, no, send it out to open market. Right? And then you would have had 50 other suppliers coming and saying they could do this. So again, it comes back to the point of, is it splitting or is it not? It's not, because you could have had an independent procurement event
Yeah.
that led to the award for iron ore, manganese, or NMPP.
Okay. I guess Mr. Maybeck and counsel for Mr. Singh, us being lawyers, will think of splitting of charges. Yes, continue, Mr. Maybeck.
Thank you. So there are really three things that Mr. Formick dealt with. One was parceling. Secondly, he submits that the requirements for confinement weren't met in these instances. But thirdly, what he says, and it's the thing that I want to take you to in the interest of time, is the notion of confidential confinements. Could I ask you, please, to go to page 63, PSV 63. And we're dealing still, as you know, with these four contracts.
Yes, sir.
So there he has a heading, confidential confinements. If I could fast forward, let me take you to 147 over the page. Says there, however, for reasons of confidentiality, some of the McKinsey confinements, such as manganese, NMPP, and iron ore transactions, did not follow the normal review and sign-off process. This meant that the confinements were taken to the GCE for sign-off with little or no input from reviewing bodies. The next paragraph, the 2013 PPM states that, quote, in instances where confinement is confidential, the GCE may approve such confinement without the confinement request being routed via any other authority. This was based on a provision in the 2013 DOA framework that allowed for confidential confinements. And then at 49, he says there are a number of concerns with the manner in which confidentiality was invoked in the McKinsey confinements. And perhaps before we get there, let me show you one of these contracts. You go to Exhibit BB 2.1D. This is where you find them. They were all signed by you and Mr. Malefe, these four contracts. Or four confinements, rather. Now, Mr. Formink,
Sorry, what page is it?
well, let me just retrace my steps. He says that for reasons of confidentiality, some of the McKinsey contracts, such as manganese, NMPP, and iron ore, let me take you to the manganese contract, which you find, or sorry, I keep saying contract, confinement. You find it PSV 1299. So there you will see from yourself to Mr. Malefe, manganese execution support. And if you go to page 1305, you will see that you compiled this. Excuse me, is that the 31st of March 2014?
Sorry, that is correct.
31. And your recommendation, and all of these confinements are similar, all four. Your recommendation is recommended that the Group Chief Executive approve the resourcing strategy and remuneration model for the manganese execution by accelerating and optimizing, thereby supporting the initiative to mitigate the EBITDA at risk by mobilizing a team, and then sub 2, confining and awarding the service to support the internal team to McKinsey and Company and its BE consortium partners. Do you see that?
That is correct.
Now, the issue of confidentiality arises, if you have a look at page 1302, there's firstly a motivation for confinement itself. You see that? In the table.
Yes.
And then at paragraph 25, it says, additionally, due to the confidential nature of the information, the engagement cannot be subject to an open tender process. Because in terms of para 15.1.4c of the revised PMM, in instances where a confinement is confidential, the GCE may approve such confinement without it being routed via any other signatory. Do you see? So that's a reliance on that provision in the PPM. You see that?
That is correct.
So perhaps you can keep that open, Mr. Singh, and then let's go back to what Mr. Forming says in his affidavit. I could ask you to have a look at paragraph 149. I think I'd read you the first sentence at page 64. There are a number of concerns with the manner in which confidentiality was invoked in the McKinsey confinements. First, as already stated, multiple layers of review were bypassed as a result of invoking the confidentiality provision. Secondly, the confinement memos contain very little, if anything, that explains why the submissions were confidential. And then thirdly, in addition to invoking confidentiality as a reason not to route the confinement memos through the normal sign-off process, the submissions erroneously invoke confidentiality as a reason for confinement itself. And then 152, fourthly, in certain instances, the confinement memos made no claims to confidentiality. Well, we're not dealing with that now. But effectively, what the complaint is by Mr. Forming is that this was a confidential confinement. It was really one layer. It was compiled by you, sent to Mr. Molefe, and he approved it. Now, what was confidential about these contracts?
Mr. Chair, as I said originally, I have not been privy to this part of Mr. Forming's affidavit. In terms of the 10.6, we're not required to respond to this paragraphs of Mr. Forming's affidavit. And Mr. Chair, in terms of the document at 1299, this as well, Mr. Chair, I have not seen this document before. So if I can have some time to be able to study this, I can obviously come back and give you some feedback.
Okay.
I mean, you will understand, of course, that you can be questioned about things that you weren't asked to put an affidavit on.
No, I agree.
But perhaps just so that, and I'm more than happy to afford you the time. I mean, it's a very important issue. Maybe what I can do is I can just show you where there are other, perhaps we can look at all four of these confinements,
yes.
And then over lunch or whenever you can have an opportunity to look at it. If you go to page 1283. 1283, here you find the coal contract or coal confinement. You'll see that it's at 1289, compiled by you, signed by Mr. Molefe. And you will see at 1287 that there's reference to the confidential nature of the information. Then if you go to 1291, is the Kumba contract. It's also compiled by you, signed by Mr. Molefe. And again, the confidentiality provision, you'll see on each occasion, Mr. Singh, after that table, then you get, in this instance, paragraph 22 at page 1295, the confidentiality provision is referred to. At 1299, you find the manganese contract confinement, which I've taken you to. And then the fourth contract appears at 1307. This is the NMPP. Again, at 1313, compiled by you, signed by Mr. Molefe. And you'll see at paragraph 27 at 1311. Again, there's reference to the confidential nature of the information.
I've seen that, sir.
And then perhaps what I could also do is just to assist you in this regard. If you have a look at page 1273, this is a different confinement relating to capital optimization. We're now not dealing with the McKinsey confinements, but if you have a look, if you turn then to 1280, you'll see it's another confinement, and here it goes through the various levels. Prepared by Mohammadi, recommended by Peter, recommended by you, recommended by Forming, and then ultimately approved by Molefe. The point made by Mr. Forming, in short, is that once one invokes confidential confinement, then the GCE is essentially entitled to authorize it himself, which is what happened in relation to these contracts.
That is correct.
So you'll have a look at that for us. I mean, there's simply one question really, and that is on what basis were these contracts confidential?
That.
Okay. And then if I could take you back to paragraph, or to page 500 of bundle 5B.
So we're done with forming.
Yeah. So I just want to point out to you paragraphs 51 and 52. So we know that these four contracts that were awarded to McKinsey regiments resulted in money laundering. There are two other contracts that you signed which also resulted in that. The one was the SWAT 2 contract at paragraph 51, and then at 52 it says, on the same day, 24 March, Brian Molefe issues his recommendation for the GFB contract to be awarded to McKinsey and regiments on a confinement basis without competitive bidding. This is another contract which is later discovered to have been used by regiments to launder Transnet payments through Gupta laundry vehicles. Do you have any comment on that?
No, sir. I don't have any knowledge of these laundering activities, but I do remember that we did.
Sorry?
I said I don't have any knowledge of the issues relating to money laundering, but I do remember the SWAT 2 contract, and I do recall, I think, something relating to a GFB breakthrough project.
Perhaps I can just show you that GBF contract. If you go back to Full Mink, BB 2.1D, and can you please turn to page 1315?
Did you say 5B?
BB 2.1D. At page 1315, that's where you find the so-called GBF confinement, this time not done on a confidential basis. You look at 1322, was compiled by Mr. Gama, recommended by you, and then recommended by Mr. Malefle. Do you see that?
That is correct.
And it's addressed then to the BADC.
Yes.
Goes through various levels. Now, Mr. Singh, that brings me to the issue of invoice tracking. Could I ask you please to turn to page 698 of bundle 5B.
698. No?
And so, you know, this is the second money flows report that you were provided.
We only, so from my knowledge, we only received a 3.3 notice relating to the McKinsey money flow stuff.
Yeah, well, this is what we're dealing with. We've got two. Well, you've seen this.
We'll check and confirm.
Okay, well, let me,
We can carry on.
I mean, I can take you back to the notice if you want, but as I recall, and you must tell me if I'm wrong, what happened here is the following. There are two reports in your exhibit. The one report is at 490. Do you see that? That's the one that we've been discussing, which sets out the 4 confinements in 4 days. You see that? Mr. Singh, you've looked through these. You've seen that report, correct? We've been dealing with.
Chairperson, just for the record, is my learned friend saying that we got this per a 3-3 notice?
Well, I just want to confirm what the problem is here.
Yeah.
Just so that I'm just trying to take Mr. Singh to the reports and to just identify what the concern is. In the bundle, Mr. Singh, and we can come to the issue of 3-3, there are two money flow reports. You've seen that?
Yes.
Okay, so the one, and I'm not trying to quarrel with you, I just want to see if there are any issues.
No, can you answer?
The one you find at page, it starts at 490, and it's headed or titled, Report on Vickers Cigar's Relationship with Regiments. You see
Yes,
that?
sir. Yes.
Now, that is the report that you and I have already dealt with in some detail already. For example, at 499, we've dealt with the 4 confinements. There are a lot of annexures to that report, as we've seen. It's got the RFPs, etc. The next report, and this first report on Vickers Cigar is dated the 14th of November. Next report is contained at page 694, the second report. This is dated the 13th of November. It's a report on the laundering of regiment's proceeds. You see that?
That is correct.
And that report too contains a series of annexures, I think goes all the way up to I think it's 768.
Yes.
Now, do I understand you to be saying that you never received you received the first report? Because remember, and while I may not be entirely familiar with the facts, these came from money flows, not from Transnet.
No, I'm familiar with this.
Okay, you're familiar
move on,
with it?
yes.
All right. So let's go to this second report. And I want to direct your attention to paragraphs 13 and 14 at page 698. Are you there?
I am, sir.
Okay. So what is stated here in this money flows report is that regiments maintained a running reconciliation of the payments it had received from Transnet and the corresponding payments it had made to S's laundry entities and Albertine. Now, I mean, you're familiar with what's alleged by money flows. We needn't go back. I've put it to you many times that there was this arrangement between ESSA and regiments in terms of ESSA would get 50 cents in the rand, and Albertine, you might have read, got 5% in the form of Mr. Woodley. All right? So we can go back into the report, but if we needn't do so, we won't. So regiments maintained a running reconciliation of the payments it had received from Transnet and the corresponding payments it had made to ESSA's laundry entities and Albertine. The spreadsheet containing this reconciliation was named Advisory Invoice Tracking. The copy of the Advisory Invoice Tracking spreadsheet generated on 7 December 2015, brackets Annexure 6, shows that these laundry payments included payments on every contract with McKinsey, and that, in addition to the payments in the 2015-2016 financial year, just under another 90 million worth of laundry payments had been made in respect of regiment stroke McKinsey contracts in the 2014-15 year. Now, on the 7th of December 2015, by that time you had moved to Eskom.
That is correct.
All right. So I just want to take you then, and we're going to come back to paragraph 14. Can I just take you to this document at page 7, Annexure A, which you find at page 760.
That's 760.
Well, it's Annexure 6 starts at 760, but it's rather unusefully, DCJ, a blank page, so it's 761, yes.
Okay.
So here's a series of spreadsheets. You've had an opportunity, presumably, to look at this, Mr. Singh?
No, I did.
All right, so what one sees, and perhaps I'm just going to go to things that we're familiar with. I mean, we've spoken a lot in your evidence about the China Development Bank. So if you go and you run down the second last set of rows, you'll see there's the date 2 June, and you see project in the middle, China Development Bank. Do you see that?
What page are you on, sir?
I'm at page 761,
Yes.
and the second last set of rows. Another way to track it is to go down in the date of invoice to 2 June 2015, towards the bottom. Are you there? Date of invoice 2 June 2015, then there's an invoice number, and then there's the project, China Development Bank. There we see the 189 million that was paid. We've been through this. You see that 147 on the schedule was paid to Albertine. You see that?
Yes.
And I think I've told you that what happened to that money after that is 122 million was laundered to Sahara Computers. But this gives you a sense then, doesn't it? I mean, if you drop down a few lines, 1, 2, 3, there you see the NNPP contract we've been speaking about. You drop down 2 lines under that, you see the GBF breakthrough contract, which we've just discussed. You see that?
I do, sir.
All right. So if we go back then, please, to paragraph 14. At page 698. Regiments forwarded copies of the advisory invoice tracking spreadsheet to Anoj Singh when he was the CFO of Transnet. See, for example, Annexure 7, email of Wood to Singh on 18 May 2015, and to his successor as Transnet CFO, Gary Peter. See, for example, Annexure 8, email of Wood to Peter of 5 August 2015. Then they say the CFOs of Transnet were aware of the payments being made. By regiments to S's laundry entities. Now, can we have a look then at this Annexure 7, which you find at 765. Are you there?
I am there, sir.
So, at 766, we start at the bottom. From Yvonne McCorney to Eric Wood on the 18th of May, 2015. Good day, Mr. Wood. Attached is the updated schedule. And then, shortly after that, I think 2 minutes later, Mr. Wood forwards it to you. Subject revised outstanding revenue, attachments invoice tracking 2015, 2016. Hi, Anoj. I've attached the list of OS, I assume that's outstanding. You confirm that?
That is
Invoices as requested. You see that?
correct. That is correct.
We have then provided you with the attachment. And that attachment, and in fact this email, appears in bundle 5C at page 1932. And your attachment is at 1924.
Please just repeat the bundle, Mr. Mather.
Goes back to the B bundle.
5B,
5C.
5C.
Yeah.
Just repeat the page, 19 what?
Page 1923.
Lisa.
All right. So the attachment, we provided you with a number of schedules comprising that attachment. They run from 1924 through to 1935. You see that?
That is correct.
Now, if you go to 1924, what's written at the top by one of the investigators is that when you open this document, this is the first view. And what you see here is, I think importantly in the third column, the invoice date. Then we have the project, and you have the amount. You see that? And it's indicated whether it's been paid or outstanding. You see that?
Yes.
Sorry, Chairperson, we can't hear the client.
Yes, we can.
So may I just ask for some advice?
Yeah.
All right. I'm sorry for the interruption, but I had asked because this is quite important for us all to be provided with color copies. I understand that you don't have color copies, DCJ, is that right?
Well, on page 1924 and 1925, I have colored portions of the tables.
I see you've got, for yours, color copies.
Well, one column is color. Well, it's color copy, yes.
So I think
So in other words, unlike the one where we were
Yeah.
just now, which was colored all over, this one is just certain blocks that
no,
are
that
colored.
may be correct. I think I might be at a disadvantage because I don't have color. So what's happened to mine, it's been photostated and then the color obscures it. So I'm at a bit of a disadvantage. But DCJ, perhaps this is something, if I was given an opportunity, I can try and sort out.
Yeah, no,
at lunchtime.
let's do,
All right.
deal with it after lunch if you'd like.
No, I'll go through it now.
Oh, okay, all right.
So that's the first view. Mr. Singh, are you with me?
I'm with you, sir.
Then if you go to the second view, it says unhide columns G to J.
And when I can see the first view, but I don't see where the second view is.
Okay,
I
well,
thought it would be the next page, but it's not written second view on the next
No,
page.
well, these things follow. It's numbered number 3. Only because, as I understand from the investigator, what he had in mind is that the email would be 1.
Yeah,
So,
okay. Okay, so the second view is at page 1925.
that's correct.
Okay,
So what you then do is one clicks on this Excel spreadsheet to unhide columns J to G. And then what happens is you see from the amount column, which one found at the first view, this then unlocks the 1, 2, 3, 4, 5, the six columns on the right-hand side. So it unlocks columns headed Chavita, Homex, etc. Albertine, do you see that?
I see that.
So what this second view shows you, for example, is if you track down to 15 March, the number of invoices dated 15 March, we've got coal, NMPP that we've dealt with, and in fact even one of the SWAT contracts we've dealt with. You'll see the amount that's due, and then you will see Chavita or Homex. In all of those instances, it reflects that they're getting half of the fees. You see that?
Yes.
So let's take coal at 1,337,599. That 66,800 is 50% of that. And then you will see that Albertine is getting 5%. You see that? So 66,880 is 5% of 1,337,000. Do you see that?
I see that.
And so it goes on. And then the same, that's March, the same would happen in April. Then if one goes to the next view, where you unhide certain rows, all that this really does is then enables one to see what invoices have been paid. You see that? So in other words, the view before said bank date, that was absent. There was no information in the last column. But if you go to page 1926, you'll now see the right-hand column is populated. You see that?
Yes, sir.
Reflecting the bank date.
I see.
You see that, Mr. Singh? Are you there?
Yes, I'm there.
So in other words, the difference between 1925 and 1926 is that the bank date, that far right-hand column, is now populated.
I see that.
All right. And then there's a whole lot of other information that the investigator has marked 5, 6, 7, 8, 9, 10, 11, 12, and 13, none of which is of particular moment for present purposes. The three important views then are the first, second, and third view, pages 1925 1925, 1924, 1925, and 1926. Now, to begin, can I ask you, did you receive this email from Mr. Wood on the 18th of May?
Mr. Chair, I don't recall the email, but I guess if it's arrived at my Transnet email address, I can say I've received it.
And did you have occasion then to open the email? Can you remember that?
Mr. Chair, I don't recall whether I opened this invoice or not. I mean, this email.
So it says, if we at 1923, hi Anoj, I've attached the list of outstanding invoices as requested. Had you requested Mr. Wood to provide you with a list of outstanding invoices?
Mr. Chair, I think we'd need to explain a bit of background behind this. And in order for us to do that, Mr. Chair, I would ask that we go back to the previous file.
Before you do that, but will the answer ultimately be yes, you requested, or no, you didn't request, or you want to check something before you say
Well,
you
Mr.
did
Chair,
or you didn't?
I don't recall, as I said, this email or the circumstances behind this. I can only think that this would have been a invoice, or these were outstanding invoices, as you would see from the, as Mr. Wood's message says, outstanding invoices. And if you then go to the 1924, you will see it is list of outstanding invoices. And you will see that this mail has come to me in May, and it actually has December, January, March invoices reflected thereon. So these are long outstanding invoices. So my only view in terms of why this would have come to me was that these were long outstanding invoices that would need to have been in some way, shape or form settled. Or we would have need to investigate why have these things been long outstanding. Now, Mr. Chair, why I wanted to go to the other email, this email is actually the email to Mr. Peter in August. But it actually gives more clarity as to why this invoice actually, or these invoices came to us.
Okay, you may go there.
Thank you.
Mr. Chairman, I see it's almost exactly 1 o'clock. Is this not perhaps a good time to break? And I'll then see if I can get myself some color copies in the interim.
Okay, all right. So you'll continue with that answer after lunch?
No
Mr.
problem.
Singh. We'll take the lunch break. We'll resume at 2.
Thank you.
Thank you.
We adjourn.
See, Mr. Chair, if we now go back to my document, which is in 5C,
Yes.
basically you would see that, again, it refers to outstanding invoices. So the context, Mr. Chair, is that Mr. Wood would have had a discussion with me regarding Regiment's outstanding invoices. He would have then sent this email to me, which I would have received. I would have then opened the invoice, the email, and as you would have then seen, Mr. Chair, it would have taken you to page 1924. And there is the list of outstanding invoices. As you would see in the second column, December 2014 invoices, 2 invoices outstanding. January 2015 is another invoice. And then you have 5 March 2015 invoices. And there's a whole host of April, and then you'll see February, January, and February invoices as well in the last block. So, Mr. Chair, this is the context within which the email would have been received by myself, and I would have then dealt with it accordingly, Mr. Chair. The other point to make, Mr. Chair, is that if you have reference to page 1924, Mr. Chair, you would understand that an email that you would receive would look like 1923. So that's what you would see when you open the email. Then there would have been an attachment that was attached to the email, which is then 1924. And Mr. Chair, I think the investigator here is trying to basically say, which is what I would have seen when I opened the attachment, is this list of outstanding invoices. And that's all I saw, Mr. Chair. I had no knowledge or clue that the spreadsheet contained all of this other documents that are reflected from page 1925 right through to, I think, 1935, if I'm not mistaken, Mr. Chair. These documents that are attached to the reference bundle from 1925 to 1935 would require that you actually physically do something to the spreadsheet to be able to access these, let's call it hidden data. And you will see, Mr. Chair, as the investigator has written on 1924, he said 3, unhide. So if you performed a function on Excel to unhide columns G to J, then you would see these columns. If you then had to unhide the rows on 1926, it would then reflect those rows. 1927, if you performed an unhide of those tabs, you will then see the March tab. You will then see the April tab, the May tab, and so on. But this required physical, firstly, you needed to have knowledge that these things were there. Secondly, you then needed to actually go and physically unhide these things.
Yes, thank you.
So firstly, Mr. Chair, I can confirm that I had no knowledge of the fact that this spreadsheet contained this information. Secondly, I did not perform any unhiding of any of these documents. Mr. Chair, the first time that I can honestly tell you that I became aware of the fact that the spreadsheet contained this hidden information was actually when we were here and we were presented with this spreadsheet. And we said, from what we can see, it only has one sheet. And then we engaged with the investigator who then explained to us that if you do this and you do this and you do this, it then reflects all of this stuff. So, Mr. Chair, from my perspective, I had no knowledge of any of these spreadsheets. I did not perform any unhide functions. And to the extent that the Commission has access to my emails, whatever tests you can perform to identify if I did in fact, unhide any of these things or have access to this information, you're more than welcome to do, Mr. Chair.
But Mr. Singh, you work with spreadsheets all the time. So when you talk about unhiding, it's really clicking on a tab, right? It's not some sort of mysterious computer program. It's simply clicking on a tab.
Well, firstly, you need to know that it's
Yes,
there.
but then that's all it is.
Yeah, but you need to know it's there. Then you click on it and then it comes out. But
Well,
from my
maybe we-
perspective, I wouldn't be looking for that.
Maybe we'll need to demonstrate it for the assistance of the chairman, perhaps on another occasion. But I mean, you accept it just has to be clicked.
Chairperson, maybe my learned friend must just give my client an opportunity to finish his answer before he interrupts him with another question.
Well, I didn't think he interrupted him. I thought he said everything he wanted to say. Mr. Singh, was there anything else you wanted to say?
No, sir.
No, okay.
Thank you. And then I wanted to, what is very strange here is Mr. Wood obviously trusted you with this information.
Well, I don't know if Mr. Wood actually knew that this information was there. Or if
Sorry?
I said I wouldn't know if Mr. Wood knew this information was there or not.
It's one thing for you to say you didn't know it's there. It would be quite another thing to say that Mr. Wood, these are his spreadsheets that he's sending to you, wouldn't know it's there.
Well, hence I'm saying I can't speak for Mr. Wood.
All right. So, just that I understand this, the email from Mr. Wood to you says that you requested a list of outstanding invoices.
Yes, sir.
Is that right?
Well, according to the email.
And would that be normal? I mean, I've seen, you've seen, for example, in the Eskom judgment, you came in for a lot of criticism in dealing with service providers in respect of the payment of invoices. You remember that?
Well, it's not, in my view, it's not extraordinary. I think, as
Sorry,
I
I
said,
can't hear you, Mr. Singh.
I'm saying it is not extraordinary for a CFO to deal with outstanding invoices. As you would have seen, Mr. Besta and Mr. Samshin also were complaining about outstanding invoices and wanted to have a meeting.
Yeah, except you say you never went to any such meeting and had
Exactly.
nothing to do with them.
Exactly.
Yeah, I don't know how that helps you.
No, I'm saying, but it's not unusual on their version to be dealing with a CFO for outstanding invoices.
Well, just in relation to that, that's very unusual because there was in a meeting at a restaurant and Mr. Esser was there.
Mr. Chair, we're going to traverse this again.
Maybe you shouldn't go down that road. All right.
Well, you brought it back, Mr. Singh.
Okay, so I've asked you about how you would unhide these columns, and I've asked you about why it is that Mr. Wood would trust you with this information. Is it your version that you didn't know anything about these payments to Chavita, Homex, and Albertine?
No, sir.
Not at all.
No, sir.
I mean, you didn't even know that they were supply development partners.
No, sir.
Let's just have a look at this. And do you accept as well when one works with a spreadsheet that what one does if you hit a tab or unhide columns, really what it does on your computer is it enables it to become bigger because not everything fits the first time round on the first view, correct?
I don't understand.
Well, Mr. Singh, you presumably have very sophisticated computer skills.
I would say I'm average.
And I would assume that you've got good Excel computer skills.
I would say average. No.
Yes, but you, as the Group Chief Financial Officer of Transnet and Eskom, this is your bread and butter. Excel spreadsheets, correct?
Not really, sir.
Mr. Singh.
You don't want to associate yourself with average, Mr. Singh. Do you want to do that?
Well, Mr. Chair, if you're the group CFO of Transnet, Mr. Chair, it doesn't mean to say that you actually work with Excel spreadsheets every day.
Yeah, well,
Excel spreadsheets are prepared for you.
that was on a lighter note.
No, but I'm responding to Mr.
But I'm being, honestly, I mean, is this not your bread and butter?
No,
Excel spreadsheets?
no, sir.
Well, how, all right. Well, we'll come to perhaps a demonstration in time, but are you not suggesting that you're unfamiliar with the working of Excel spreadsheets?
I'm familiar with the working of
Yeah.
Excel spreadsheets. As I said to you, I am, if you had to grade me, I would I would tell that my self-assessment on Excel would be average.
So you see, Mr. Singh, for example, I think everyone's learned this lesson. What's happened to me is an attorney I've sent you the information, you get the Excel spreadsheet, you phone the attorney, you say it's not here, and he says, you idiot, you press that tab and there's the next spreadsheet. I mean, we've all learned those lessons,
Yes.
hey? Correct.
Yes.
Can we just have a look at some of the other stuff that was sent to you? Go to 1927.
1927.
1927. Yeah, you see that on the face of it, it's historical information going back to March 2014. Do you see that?
That is correct.
I mean, there, for example, you will see the second payment, the 1064 transaction advisor. In that month, the bill was 6 million. Chavita got half, and Albertine got 5%. You see that?
That's correct.
And then if you go to 1928, again, it's another representation of that. You see the 1064 advisory services in March.
Yes, sir.
So this other information, other than for the first screenshot or screen view, have you any explanation why Mr. Wood would send it to you?
I have no idea.
And would you have any idea why he would send the information to Mr. Peter, the person who succeeded you?
Mr. Chair, as I've said, I think for the purposes as I've read out from the email.
Then, if we can go back to, did you have an opportunity to look at those McKinsey confinement contracts over lunch?
I did so.
There's just the one question, and that is the issue of confidentiality.
Yes, Mr. Chair. I think from the documents as we've gone through them, the reasons for the confidentiality is not mentioned. And
Is not?
is not mentioned. And I would need some time to go through my records to identify the reasons for those, the need for the confidentiality. Also, Mr. Chair, these documents that what was placed before us today, was not part of the as I mentioned, it was not part of the 10-6 notice in order for us to respond to Mr. Volvink. The particular documents relating to NMPP SWAT, manganese and coal and iron ore, were actually requested from the Commission when we engaged with the Commission relating to the 10-6 notices. And these particular documents were not provided for us. So, Mr. Chair, I would respectfully request that we be afforded some time to be able to deal with these documents, and it would seem like we are coming back for another day.
Well, I don't know about that, but...
But either way, Mr. Chair, we will deal with them.
We're happy to afford you that time. Just so that you know, of course, you were sent the whole of Mr. Formick's affidavit and all the annexures. And these issues are in the summons, but I'm more than happy to provide you with the time. It's a difficult issue.
Chairperson, sorry.
Yes.
My learned friend can finish. I just want to place on record that what was sent to my client is the affidavit and one single annexure. The fact of the matter was, as my client has already stated, there was a request more than once to be provided with those documents, and it was placed on record, to the best of my recollection, my attorney can correct me, that we need those documents, these, whatever it's called.
Spreadsheets.
No,
Not
The memos, the memos.
the
the
memos
memos,
in
yeah.
order to properly deal with them, and we were not given it. The first time that it seems on the face of it, those documents were forwarded, is now on the 25th, when we were sent an updated bundle.
Well, Mr. Chairman, I've made my position clear. I'm happy to afford,
Yeah.
as you saw, I was happy to afford Mr. Singh the lunch hour. If he needs more time than that,
Yeah.
I have no difficulty. And it's really, it's a one-point question. And he has all the documents. If there's anything else you need from us, tell us, and then we can deal with it.
Thank you, sir.
And insofar as we may not return, it seems that that's a thing that could easily be dealt with on affidavit, because it's just a simple answer.
Thank you.
You might also want to have a look at Mr. Malefe's evidence, where I think with respect he struggled to explain the issue of confidentiality.
Will do, thank you.
Right, let's turn then to the procurement of 95 locomotives. Just incidentally, before we get off this, so what did you do when you received this information from Mr. Wood? Did you then go and chase up the payments and make sure they were all paid?
Mr. Chair, as a matter of course, I would have referred to the spreadsheet, as we call it, the first view. I would have had a look at which invoices were outstanding, and I would have then sent it to the respective individuals, I think, Mr. Mohammadi or Mr. Mohammed or whoever was actually in charge.
And would you then have made sure that they were paid?
They would have then followed them up, or they would have come back and said, this is the reason it's outstanding, this is what we're doing with it, and then they would have had to resolve whatever they were.
Yes, but would you have ensured that the invoices were paid?
I would have not been the person that actually physically went around, running around and fixing them up,
Yeah.
but eventually they would have got paid.
I see.
I guess Mr. Mabe's question could be put this way. They must have sent them to, Mr. Wood must have sent them to you to take necessary steps to ensure that payment was made.
Mr. Chair, these relate to long outstanding invoices.
Yes, I'm talking about that.
Yes, so these invoices would have been delivered to Transnet with the required supporting documents to the appropriate person who they were dealing with.
Yes, but they were not being paid.
They were not being paid.
Yeah,
and
that's the point. That
yes.
He
So
must
he would have then requested my
Yeah.
intervention to
Yeah.
find out what is happening
Yeah.
or what is the issue.
Yeah.
And then we would have then resolved the issues, and then they would have been paid.
Obviously, from his point of view, he didn't know of any reason why payment should not be made.
That is correct.
So he probably wanted somebody to take steps to try and make sure payment was made.
Indeed, sir.
Okay, all right. Mr. Mabe?
Thank you. Just on that, just one related thing. When did you first come to learn that Mr. Esser was involved with Trillion, was an owner of Trillion?
I think it was when McKinsey informed us that they were not going to partner with Trillion anymore. I think that would have been March 2016.
At the time at which you were at Esser?
It is.
March 2016.
Yes.
All right, can we turn to the procurement of, let's start with the 95 locomotives. And let me just paraphrase some facts so that I can get to the point there where I want to be. Would you confirm that in September of 2012, CSR was appointed as the preferred bidder for the supply of the 95 locomotives at a cost of some 2.5 billion rand?
Mr. Chair, the date I'm not too sure, but I do know that CSR was appointed as the OEM to supply 95 locos.
Can we go, please, to POR bundle,
Sorry, sir.
Transnet Bundle 6.
Just give me 1 second.
Yeah. You'll see there at page 93,
Black numbers again?
yeah, you'll see at paragraph 5.5, a bit of a mouthful, point 18.44. Says, according to a letter dated 5 September 2012 from Malefe to PAN, Transnet notified CSR of its appointment as the preferred bidder. In the letter, CSR was requested to sign the agreement by no later than the close of business on 6 September 2012. Do you see that?
I see that.
If I could ask you please to go to page 39, and this is in the section dealing with the 95 locomotive.
39.
39.
Yes, sir.
With reference to the table at page 39, would you confirm that at this time, in September 2011-2012, Mr. Sharma was a director of Transnet and a member of the BADC?
From my recollection, he was, yes.
And you, of course, were a director, we see from that table, ex officio, correct?
That is correct.
And we know that in August of 2012, Mr. Sharma was appointed as the chairperson of the BADC. You know that?
2012.
I think it's 2013, I beg your pardon.
No, this table refers to 3 August 2011.
Yes, exactly. That's why I'm trying to work out if you know when Mr. Sharma became the chairperson.
Oh, no, I wouldn't.
You don't know that?
No,
Okay.
no.
All right. So what was your involvement in the acquisition of the 95 locomotive?
Mr. Chair, if I recall, I had actually a limited involvement in the acquisition of the 95 locals. It was really a project that was run by Transnet Freight Rail. And I think, if my memory serves correctly, I would have signed off on certain memos that would require to be submitted to the board or to the Capital Investment Committee in relation thereto.
So we've seen that you were at a meeting reflected in paragraph 5.5.9.8, and then also, if you
Paragraph
go...
number? Paragraph number?
Paragraph 5.5.9.8, that table at page
Okay.
39.
Yes, that was, as I said, I would have signed off memos and attended the board meetings or CAPIC meetings where these were discussed.
And then there's reference to another board meeting at page 41, a board meeting on the 31st of August, towards the foot of the page. And there you will see over the page, at paragraph 5.5.9.18, you were present at that board meeting as well,
Yes.
as was Mr. Sharma.
Yes.
Now, as you know, the money flows investigation has revealed that CSR, in relation to the 95 locomotives, and Regiments Asia, which is another of Mr. S's companies, entered into a BDSA with it getting in this instance, a 20% kickback. And as I have the evidence to date, money flows have identified that payments to the tune of some $17 million have been made by CSR in this regard. I take it you say you had no idea of the involvement of Mr. Esser and or Regiments Asia.
That is correct, sir.
Now, Mr. Singh, perhaps I could just ask you to comment on this generally. And how is it that there's 20% fat left, assuming that that was the kickback that was paid here? Is that possible?
Mr. Chair, I would not be able to comment. I'm not au fait or in any way an expert on locomotive pricing, so I wouldn't be able to comment.
So when we get to the 1064, and something perhaps one might want to reflect upon. I mean, there you were in the negotiation.
Yes, sir.
There's also one of these BDSAs concluded there, it's a 21% kickback. How could there have been enough fat for a 21% kickback if these negotiations were conducted thoroughly and in a bona fide way? If there was hard bargaining, how could it be that there was enough space, if you get the point I'm making, to pay that kind of kickback?
Well, as I said, Mr. Chair, I wouldn't be able to comment in terms of the margins that the OEMs believed was appropriate for them to earn. Certainly from what I can recall of the process that was followed for the 95s and the 1064s, it was a very thorough and rigorous process in terms of the negotiation that occurred.
Well, one would have thought that quite some work would have been done to ensure that if there was an inflation of prices, that would be picked up.
That is correct, sir.
And if it wasn't picked up, that there was so much that could go to kickbacks, doesn't look like a proper job was done in terms of checking.
Well, Mr. Chair, as I said, from my perspective, I think all of the escalations were justified and were as a result of economic variables that had changed during the tender phase as well as the contract negotiation phase. And I guess we'll deal with that when we come to the 1064 locals.
I mean, it's difficult to say that if the price includes 21% kickback, can be said that the price is justified.
Well,
That's
Mr.
such
Chair,
a high amount of kickback.
well, Mr. Chair, as I said to you, if the OEMs decide to make a lower margin for whatever reason, then that's something for them to decide, but nothing to do with Transnet.
So my back.
Yes, thank you. Do you know what the margins are in locomotives?
And not offhand, no.
But I mean, was it something that you engaged in during the course of negotiations, presumably?
It's not something that one would ordinarily pick up. So it's very difficult information to get hold of. And that was one of the reasons why the transaction advisors were appointed, particularly Art.
Do you see the irony? One of the reasons why transaction advisors were appointed. I mean, do you see what happened with those transaction advisors?
Yes.
You rely on them to advise you.
Mr. Singh, when you reflect on this, do you think that those transaction advisors advised you properly? I mean, now that you know the facts.
Well, Mr. Chair, in terms of the work that was required to be done, I would reflect and say, yes, Mr. Chair, because as far as I am concerned, as I said, when we deal with the issue of the 38 to 55 billion, Mr. Chair, you will see that barring the issue relating to the element of contingencies, pretty much all of the increase related to economic variables. So from that perspective, Mr. Chair, there leaves little room or manipulation of the numbers.
Of course, you don't mean that if we could go back in time, you would still use them.
Mr. Chair, well, having known what we know now, but given the same information then, you probably still use them. But given what we know now, maybe not.
Can we then turn to the 100 locomotives? So here CSR was awarded a tender on confinement, replacing Mitsui, correct?
Sorry, sir?
And an LSA was concluded on the 17th of March 2014 at a cost of approximately 4.3 billion, the ETC having been 3.8 billion, approximately.
That is correct.
And 17 March was the same day as the LSAs in respect of the 1064 locomotives were concluded.
That's correct.
Perhaps you could just explain, I'm not sure, I know it's amongst the documents, but maybe you could just explain to us the reason why the 100 locomotives were acquired at this time.
Were acquired as?
At this time.
Okay. Mr. Chair, if I recall correctly, there was a need for... Okay, let me explain it this way. Let me start here. And maybe we can then... We'll go backward in time, Mr. Chair, if you allow me, because this is how I understand it.
Yeah.
But I think it will then fit into the chronology of everyone else's events, but this is how I understand it.
That's fine.
There was the coal line was experiencing a problem in terms of meeting its budgeted volumes. And it was a periodic shortfall week after week after week. At Transnet, we actually measured the volume, the budgeted volumes on a weekly basis. Because in Transnet, revenue is actually one of the most significant, well, actually in any company. But so we tracked revenues on a weekly basis, and particularly budgeted volumes. So it became a perpetual, what we called cash flow at risk item. Because if you didn't earn the revenue, you certainly didn't earn the cash flows associated with the revenue. And this was then tracked weekly. So we used to have these exco breakaway sessions where we used to discuss all of these, let's call it, cash flow shortfalls and the reasons therefore, and what plans do we need to put in place to mitigate. And we had a series of these meetings, and as we got to a point in time, I then engaged with Mr. Molefe and I said to Mr. Molefe, listen, we're continuously having this issue with this coal line, and the coal line is not performing up to volume. And that's when Mr. Molefe engaged with Mr. Gama to understand what was the issue relating to the coal line. And Mr. Gama then responded and said, locomotives. You give me locomotives, I can deliver the volumes. And the coal line locomotives that were required was contingent upon the 1064 locos having come on stream at a certain point in time, which would have then allowed for some general freight locos, I think, to have been deployed to the coal line. That would have enabled Mr. Gama then to meet his budgeted revenue volume. So this was the way that this thing worked out, that the cash flows at risk on the coal line was due to a lack of locomotives, and therefore it triggered this procurement event.
All right. Now, we know that at this time, Mr. Sharma was the chairperson of the BADC's director. We know also that SA in the form of Regiment's Capital here as well concluded a BDSA with CSR for 21% kickback. There's just one question which I perhaps haven't asked you that I would like you to comment on. Have you got any idea what it is that Mr. Essa, you've looked at some of these agreements. I think you've looked at the Tequesta agreement.
That they were part of the bundle.
why do you think, are you able to proffer any view, why was CSR paying this money, this kickback, for what?
I would have no ideas.
You've read the contract.
Yes.
They seem to indicate that they're brokers and they have influence and they can pull off the deal.
Yes, sir.
Do you say that didn't happen?
No, sir.
All right, can we then, in relation to the 100 locomotives, can I take you to Mr. Callard's affidavit, please? That you find at Exhibit BB4A. And could I ask you please to turn to page FQC6? So, Mr. Singh, this is stuff that we've been through with other witnesses, and the chairperson is familiar with it. I'm going to try and paraphrase it and walk through this quickly. If at any time you either want to look more carefully at it, please feel free. But I'm just trying to set out the chronology and sequence so that we can get to the point that I'd like to question you on. You see at paragraph 26 at page 6, Mr. Kellard says that he prepared the first business case in April of 2012. And then at 26.1, he says in September, October 2013, he was requested by GAMA to update the memorandum to the BADC. And he says that the memorandum dated the 15th of October 2013 was signed by GAMA, Peter Mohammadi, and you. Do you see that?
That is correct.
And we know, and this is stated at paragraph 27, that that memorandum recommended confinement to Mitsui. You agree with that?
As I recall, yes.
So that's in September, October 2013. If I could ask you to go forward then to paragraph 32 at page 7, he says, I was informed through an SMS from GAMA on 21 October 2013 that the Group Chief Executive, Mr. Molefe, had withdrawn the memorandum at the BADC meeting on the same day. You see that?
Yes, sir.
Then at paragraph 34, Mr. Kellard said, I later prepared an updated version which GAMA signed on 25 November 2013. You see that?
Yes.
And if we go to the next year, January 2014, at paragraph 38, at page 9, he says, on Monday, 20 January 2014, I mailed a PDF version of the revised business case to GAMA. You see that?
Sorry, where are you now, sir?
Paragraph 38, page 9.
Oh, sorry. Yes.
Let me go through that again. On Monday, 20 January, I mailed a PDF version of the revised business case to GAMA. You see that?
Yes.
Then he says at 39, paragraph 39, on the morning of Wednesday, 22 January 2014, I received a mail from Lindiwe Adleche from Supply Chain Services requesting my assistance on formatting my memorandum of the previous Monday. When I perused the memorandum, I noticed that the memorandum had been changed to give effect to confine an award to CSR for 100 electric locomotives. Do you see that?
That's correct.
So that's on 22 January If I could take you then, please, to page 10, at paragraph 44, he said that I deliberated long and hard on the Wednesday evening on the implications of what I'd learnt. On Thursday afternoon, 23 January, I emailed Garma and Gianni expressing my concern at the unilateral changes to the business case stroke memorandum I'd submitted on the Monday. And then if you go to paragraph 45 at page 11, it says, my email to Garma and Gianni opens with, and he quotes, "This is a difficult mail to write. In helping to format a recent version of the 180 locomotive business case on Wednesday 22nd, I noticed that the case was changed from that which I had submitted on Monday. This mail is because of the nature of those changes and the implications. The implications are technical, and the rationale for the acquisition, which was speedy delivery to mitigate MDS volumes at risk." You see that?
I see that.
And then he sets out at paragraph 46 what his concerns were. And then if you go to paragraph 48, he states that during the preparation of my statement, the Commission provided me with 3 pertinent emails from which it is evident that Garma Singh and Molefe had knowledge of my concerns, per the email trail below. Sub 1, the first was an email sent from Garma to Singh late on 23 January, essentially reflecting my concerns. It reads, and this is now from Mr. Garma to you, "Hi, Mr. Singh. I'm afraid the submission on the 100 locomotives is a mess and will need to be withdrawn. The 20E locomotive is a 22-ton per axle locomotive suitable for GFB, while the 19E locomotive is a 26-ton per axle beast suitable for the coal line. The 2 locomotive types are not interoperable. While CSR can make additional locomotives in China in a very short space of time to mitigate against MDS volume loss, this will be counter to our localization strategy and would have to be spelt out. The 85 locomotives to be assembled by TE has not yet commenced, so we cannot yet make an argument that this would reduce the risk." You confirm having received that email?
Mr. Chair, again, I don't recall the email, but if I don't have any reason to believe that I did not receive it.
Well, it seems you must have, because at 48.2, the second email that was provided to Mr. Callard was from Singh to Garma on the morning of Friday, 24 January, saying that they would discuss the matter this morning. Let me take you there so that you can refresh your memory. If you keep your finger at page 12, you can turn to page 221.
221.
So that's a cover page. The email itself appears at 222. So there you find Mr. Garma's email at the bottom, and then your response on the 24th of January, the morning, 7:02. Let's discuss this morning, on 24 January.
I see that, sir.
And if you go back to page 12, paragraph 48.3, the third mail, also on the morning of Friday 24, was where Singh forwarded Garma's mail to Molefe for information. That you find at page 225. See that?
So this was when I sent it to Brian, yes.
Yes. From Anoj Singh, 24 January, 7. to Malefe FYI, thanks. See that?
That's correct.
Then if you go back to page 12, there was that day a BADC meeting, correct?
That's correct.
And let's go to those minutes. Those you find at page 228. So what you see at 228 is that Mr. Sharma was the chairperson, and then in attendance were you and Mr. Malefe, and in partial attendance at 1.4 was Mr. Gama and Mr. Gianni. You see that?
Yes.
At the foot of that page, 5.1, you see that what's recorded is Messrs. Gama and Gianni joined the meeting at 11:55.
Yes, sir.
See that?
Yes.
And what we see at page 232 is the acquisition of the 100 locomotives was then discussed as item 5.2. Do you see that?
That is correct.
And then if you go to page 237, you will see just above item 5.6 that Messrs. Gama and Gianni were excused from the meeting at 15:03.
That is correct.
And if I could then take you back, please, to page 232.
232.
Yeah. So it reads at 5.2.1, management took the committee through the submission as contained in the pack. Now that's the submission to confine to CSR, correct?
That would be correct.
The submission was taken as read. The purpose of the submission was to request the committee to, and it reflects then B, recommend that the board approves the investment in and procurement of 100 electric locomotives required for the coal export line, estimated at 3.8 billion. And C, recommend that the board approves the confinement and award of the procurement of the 100 electric locomotives. You see that?
Yes, sir.
And ultimately that carried the day, is that right?
Sorry, couldn't you?
That was recommended.
Yes.
Yes. Now, the memorandum or recommendation that was placed before the BADC, on that day you find at page 244. You see that? Now that document is quite a lengthy document. It runs up until 267.
That is correct, sir.
And it was signed by you, I think it appears the 21st of January, is that right?
That is correct.
and by Mr. Molefe on the 22nd of January.
That is correct.
Now, perhaps I could just ask you to explain to the chairperson how this change, almost overnight change, came about. And perhaps I want to just start off by pointing out to you that Mr. Garma didn't sign the memorandum which I've just taken you to. You know that.
No, I've seen that, yes.
Could you just explain you know that a lot of evidence has been given about this. Just explain, or please explain to the chairperson how this change came about.
Well, Mr. Chair, as I've mentioned before, the issue of the locomotives emanated from the issue of the weekly revenue reports that identified the coal line as an underperforming business unit of Transnet Freight Rail. And the reason, therefore, that was given by Mr. Gama was the issue of the tractive effort or the locomotives. At that point in time, Mr. Chair, Mr. Molefe, I think at that time or during that conversation with Mr. Gama, if I may be mistaken, decided that we should then basically confine to CSR. I'm not too sure if it was in that conversation with Mr. Gama or at a later stage thereafter, but it was then decided that we would then acquire the locomotive from CSR rather than Mitsui.
This, you say, was in conversation with Mr. Garma.
As I said, I'm not, remember I said, you asked the original question and you said, how did this 100 come about? And I said, listen, the 100 came about as a result of the underperformance of the coal line relative to our revenue tracking that occurred on a weekly basis. So when the revenue tracking indicated again that the coal line had underperformed, I engaged with Mr. Molefe to understand what are we going to do now? Because yet again, the coal line has underperformed. And this would have been on the back of previous engagements that we would have had with Transnet Freight Rail in terms of what are they doing to mitigate these volumes that are constantly being shed on the coal line. So when I had gone to Mr. Molefe to raise this continued risk relating to the coal line, he then engaged with Mr. Gama to understand what was the problem.
Yeah.
And then Mr. Gama, conveyed to Mr. Molefe that the issue was the fact that he didn't have tractive effort.
Yes, I think you and I are missing one another. I'm talking about the change,
Hence
the overnight change.
Hence I'm saying to you
Right.
that the decision then was taken by Mr. Molefe in that conversation, whether it was with Mr. Gama on the phone or with me thereafter, I can't exactly remember. But then the decision was made by Mr. Molefe to say, let's confine to CSR.
Yes, but what caused you to confine to CSR? There had been a confinement to Mitsui.
No,
I mean, I think we all accept the problem and the need for the locomotives, but it's the change that I'm interested in, from confinement from Mitsui to CSR. And that, what appears to be a change that, as you see, happens quickly. There's a business case presented by Kellogg, and we're going to come to Mr. Garma's evidence. He didn't know anything about this. First time he knew about it, according to him, was at the BADC meeting.
Well, there wasn't a confinement in favor of Mitsui.
Right.
There was, as per Mr. Kellard's evidence, there was a confinement memo that was prepared.
Yes. A business case.
No. There was a business case prepared for additional locomotives to the coal line.
Yes.
From that, you then need to have a confinement memo that actually will give effect to the procurement.
Sure.
He then prepared this, I think, according to the dates, sometime in September, October.
Yes.
Which then went, which I also signed.
Yes, we saw that.
Which then went to the Acquisition and Disposal Committee, and according to the information we just read, that did not serve, or it was withdrawn, or something happened to it. So the confinement memo to Mitsui was never signed, or was never approved, let's call it that way, which then did not allow us to buy locomotives between October. Well, actually, the business case was done sometime in March 2013, or May 2013. That was when we ought to have started with the procurement. these locals. The memo for confinement served before the BADC, I think if the date was correct, I think sometime in October. That October submission for Mitsui was not approved by the BADC or was withdrawn for whatever reason. And I think the reason was that we had confined to Mitsui before and we needed to look for alternatives and so on and so forth, if I recall. So that's the issues that the BADC had with the confinement to Mitsui. When Mr. Molefe was then confronted with the issue of attractive effort, and I would assume that Mr. Gama then explained to him this whole history around why we do not have this attractive effort. Firstly, the BADC had not approved the confinement to, or the confinement to the BADC in October was withdrawn. The 1064 locomotive procurement was behind schedule, so he needed locals from somewhere. And I think that precipitated Mr. Molefe's decision to say, well, let's confine to CSR.
Right. Okay, can I ask you, perhaps you can keep open the minutes of the 24th of January, the ADC minutes, at page 228.
228. 22.
228, you said.
Yes, of Callard. FQC 228. And then could I ask you please, Mr. Singh, to go to Mr. Gama's exhibit BB 28, bundle 7.
Bundle 7. You got bundle 7. I'm this.
Let's have a look at, if you could go to page 250.152. Insofar as that might help you, it's, to start off, it's approximately in the middle of the file. 250.152. Are you at 152?
Yes.
Can I ask you to have a look at paragraph 49.1? It reads that, according to Mr. Garner, the changes to the memorandum, and we've gone through this, were effected by Singh, who signed the memorandum on 21 January 2014. The memorandum was then signed by Brian Molefe on 22 January 2014. It should be noted that my signature was not appended to FC 14. It's the document that I took you to. I was not a party to what is alleged to have been the unilateral amendment. It was all times known to Kellogg that I supported the confinement to Mitsui and Company. I just wanted to ask you, do you accept that the changes to the memorandum were affected by you?
No, sir. I did not affect the change.
Who affected the changes?
I do not recall, sir, but the memorandum would have been brought to us, or brought to me by someone, I can't recall who. But I would have, based on the instruction from Molefe, we would have instructed someone to make these things.
Yes, but this becomes quite important. Instructed who?
I would not be able to.
What we have is we have a memorandum that's literally changed overnight. You don't know who did that, who gave input into it.
Well, from Kellard's evidence, it would seem like Mr. Mdleche was the one who was
Yes.
charged with amending the memo.
Yes, but who was the person instructing the amendment?
I would have assumed that, given that Mr. Molefe had decided that I was there, I would have been the one that instructed.
Sorry, I can't hear you.
I said, given the fact that Mr. Molefe had decided that the confinement would need to be changed, I would have probably engaged with someone in group procurement it would probably be Mr. Peter, and that would have then filtered down through to Mr. Mdleche and Mr. Gianni.
Right. So you take issue with Mr. Gama when he says the changes to the memorandum were affected by Singh.
That is correct.
Then,
Ordinarily, would the memorandum have come from Mr. Gama to you and from you to Mr. Molefe?
That is correct.
Yes. So it came to you before it went to Molefe, Mr. Brian Molefe on this occasion.
Sorry, sir.
Did it start with you for you to sign before it went to Mr. Molefe?
No, Mr. Chair, you would have seen that Mr. Gama sends me an email on the 24th taking issue with the confinement memo. So that is the very same confinement memo that I then signed on the 21st. So he can't claim that he does not know about the confinement memo. So that confinement memo was prepared. He was prepared by individuals within TFR or Transnet Freight Rail. He would have seen that because he's now commenting on it.
But isn't his position that he was against this change? He was against this change, and you and Mr. Molefe are the ones who seem to have wanted this change.
Well, Mr. Chair, if you read the comments on his email, the comments in his email related to the fact that the memorandum referred to a 20E locomotive, yet we required a 26 axle ton locomotive, which is a 19E equivalent locomotive. He then spoke about the interoperability of these locomotives, and he spoke about the issue of localization. So, Mr. Chair, in the revised memo, those three issues were taken care of. So from that perspective, I would have assumed that he was happy with the memo.
But
he was happy with the memo.
he says he would assume that he was happy with the memo.
No. Let me finish. I wouldn't know. That was when he sent us these issues. You recall, I then said I will discuss it with you in the morning.
Yes, which you didn't.
I don't recall having the discussion with him, but I'm sure I did have the discussion with him. Because then those very same changes made its way into the final memo.
All right, well, let's carry on with Mr. Gama's statement. At page 250.153, I recall having received a telephone call from Kellogg during the evening of 23 January when he informed me that confinement to Mitsui had somehow been changed to a confinement to CSR. 51.3, I indicated to him that I would liaise with Singh to establish what was going on. I sent the email referred to during the evening of 23 January 2014 after my conversation with Kellogg. The email was premised on input provided by him. At that time, I had not yet seen the email which Kellogg had sent me. It says, I agree with Kellogg concerning the matters raised by him. Then over the page at paragraph 53.1, I did not support the confinement to CSR, a fact well known to Molefe and Singh. The memorandum to the BADC was not signed by me. Want to comment on that?
Mr. Chair, I have difficulty with that because on the morning of the BADC meeting, Mr. Gama, myself, and Mr. Molefe actually met in Mr. Molefe's office. And you would see that Mr. Molefe actually approved the memo on the 22nd. Now, when was the meeting of the BADC?
The meeting of the BADC
was
on the 24th.
Yeah, it was the 24th. So I think the meeting on the morning of the 24th, there was a meeting between Mr. Gama, myself, and Mr. Molefe, where this matter was discussed. And Mr. Gama had accepted the fact that the confinement would be to CSR. And again, this is confirmed by the fact that he attended the meeting and basically accepted that the confinement was now going to be at with CSR. He didn't raise any of these issues that he now purports to raise to say that he didn't know about it or there was issues with the memorandum that we had presented to BADC.
Well, Mr. Molefe has given evidence here. He, to the best of my recollection, it's something I hope I wouldn't have forgotten, never spoke about that meeting in the morning before the BADC meeting. It seems critical on what you're telling us.
Well, maybe he just didn't recall it, but I certainly do recall that a meeting did occur on that morning. Equally so, Mr. Chair, I had occasion to ensure that the memorandum was actually signed by Mr. Gama, not on the day that the BADC meeting had occurred, but certainly subsequent to that. And once that memorandum was signed by Mr. Gama, I had occasion to file it with the company secretary. I'm not sure if they still have record of it or not, but the signed version of that memorandum was filed with the company secretariat.
You mean the one that we have here where he has not signed?
That
You
is
say
correct.
there's a signed version where he
If my
signed.
memory recalls, if my memory serves, Mr. Chair, there is a signed version of this memo filed with company secretary.
So are you saying, apart from the existence of that, the existence or non-existence of that memo where you say, as far as you recall, he signed after the meeting, after the event, as I
Yes.
understand the position, are you saying that there was a meeting where involving the three of you, Mr. Kam and Mr. Molefe,
That is correct.
where you were discussing basically the memo, the issues in the memo?
Yes, Mr. Chair.
Yeah.
And remember, Mr. Chair, this meeting is of quite a significance. It was not just that we were discussing the 100 locals. This is a meeting at which we were also discussing the 1064 locals.
Yes,
That was the bulk of the meeting actually was to discuss the 1064 locals.
yes.
So, in my view, that is the reason for us actually having this meeting, or a briefing with Mr. Molefe, so that he could actually be briefed in terms of what was happening on the 1064s, as well as the 100.
And you say he knew that at that stage, the proposal or request was for the confinement to CSR,
That is correct, Mr.
and he did not raise any issues with that.
No, Mr. Chair. I mean, the minutes are here, Mr. Chair. We presented with him being there,
Yes.
and he did not raise any concerns relating to the,
Well, you're talking about the minutes of the board committee now.
yes, sir.
Yeah, but you said there was a meeting earlier on. I thought you said there was a meeting earlier on involving the three of you.
Yes, Mr.
That's
Chair,
the one I'm talking about.
and that was a precursor to this meeting.
Yeah, yeah,
Else, Mr. Chair, I would have expected him to raise his concerns in this meeting.
yes. Well, it would be interesting to establish if there is a copy that he signed of the memo, because when he gave evidence, my understanding was that he was certainly against this. But why would he be required to sign after? What would be the importance of him signing the memo after the event?
Well, Mr. Chair, it would have been a matter of record that actually a signed copy of this memorandum did exist. Mr. Chair, one of the issues that the board and the board committees insisted on was that when documents are put before them, that they actually are signed by executives, so that they know that, someone has looked at this. So one of the things that the Secretariat actually did enforce is that we always used to ensure that documents are signed before it's presented before the board. On this occasion, because it was an urgent matter, we requested the Secretariat to basically, or I undertook to provide the Secretariat that there would be a signed copy of this document that would come. And thereafter, a signed copy of it was, I made sure that a signed copy was presented to the Company Secretariat.
And when would you have procured Mr. Gama's signature?
I'm not too sure.
But it would have been done in a few days, or it's not a matter of years or months.
No, not years, certainly not years. But it would have certainly not been a day or two thereafter. If I had to guess, it would have been the next time we either had an EXCO meeting or subcommittees of EXCO, so that when all of us were together again as a group.
But Mr. Singh, I mean, what you say now is very important. I'm sure you appreciate it.
Yes.
So just so that I make sure that I understand this, you say that on the morning of the 24th of January, you had a meeting with Mr. Molefe and Mr. Gama,
Yes.
and that whatever concerns Mr. Gama had expressed in his email to you, those concerns were satisfied, and he no longer had concerns.
No, because as you would recall as well, that very same email that Mr. Gama had sent to me, I had then sent to Mr.
I
Molefe.
understand that, but I just want to understand. Whatever concerns he had were resolved at the meeting between the three of you.
Yes, because one of the reasons,
Okay, sorry, let me not interrupt you.
I was just going to say, one of the reasons for me to having suggested that the meeting happen was not to have the issues raised at the BADC meeting where everyone was having an issue with their own issues.
And then you say he goes to the BADC meeting and he doesn't object, and in fact he agrees to the decision to recommend a confinement to CSR.
Well, he was part of the meeting and there's no objections as recorded.
And then, just to back it up, you say subsequently and shortly thereafter, he then signs the memorandum.
I recall getting a signature from him, so yes. Which I then filed with the then Secretary, Ms. Ayanda Keba.
So you say you filed it with
Ms. Ayanda Keba,
the company secretary?
yes.
What was the frequency of the meetings of this group of three, yourself, Mr. Molefe, and Mr. Gama? How
Mr. Chair,
often did you meet?
this was just an ad hoc meeting.
Or
Yes.
what's your assessment? Would it be that it might have taken weeks, days, weeks, or months before you secured Mr. Gama's signature?
I would have think maybe between, as I'm saying, logically, Mr. Chair, or practically, not logically, but practically, Mr. Chair, the chief executives of the operating divisions met or had more interactions with Mr. Molefe than myself. But in interactions with them would be at subcommittee meetings of Exco, so it would have been on a monthly cycle. So if I had to see a chief executive of an operating division, it would certainly be at least monthly. So I'm saying that I would have probably seen him again in February as part of those meetings. But remember also at this time, the 1064 locos were being negotiated. So I may have probably missed some of the subcommittee meetings, or I may have also missed Exco at that time. So it was a time where it was actually significantly, how can I say, stressed. And it was a relatively pressurized time. Having said that, Mr. Chair, Mr. Gama and I also interacted quite a bit on the 1064 locals. So again, if he had concerns about the CSR, if he had not wanted the locals, these things would have come up in those discussions.
All right, thank you. If we go back to 250.154,
Of course, Mr. Meinbeck, is it in this meeting of the BADC, this committee, that Mr. Gama said in his evidence, in his oral evidence, he didn't raise any issues because in that committee you talk, if you are talked to,
Yes.
you have no right to just talk. You have got to wait and see if you are talked to.
yes, you
in
speak
regard
if
to
you're
this?
spoken to, or something like, I
Yeah,
think he had
something like
a
that.
Zulu phrase that you then interpreted for us.
Yeah, but I think you got the part about being spoken to.
Yes.
So I think that's what's his evidence, Mr. Singh, to the extent that you say he was part of the BADC BADC meeting and he didn't raise any objection. I think Mr. Maybeck asked him about that, and if I recall correctly, his response was his position in that committee, which I take to be the position of other people who would not be members of the board, or that committee, normal members. You talk if you are asked for your view, you are asked to say something. You don't just come and talk. And that's why he wouldn't have raised any issue.
Mr. Chair, let me make 2 points in this regard. My first point is actually a point that I recall now, after you've just started with your intro. And I'm not sure if it's recorded in the minutes, I don't think it is, but Mr. Chair, at this particular meeting, for some strange reason, now, I recall that Ms. Yasmin Forbes, who was a committee member at the time, I think, if I look here, yes, she is actually a member, actually did ask Mr. Gama, do you support the submission because your signature doesn't appear on it? And he then confirmed that he actually does. And Ms. Forbes was one of those people that insisted that submissions should be signed by executive. And given the fact that he was there, I think Ms. Forbes, and I stand to correction, but this stands out for some reason in my mind, that did inquire of Mr. Gama, listen, you are here, you haven't signed the submission, but do you support the submission? And I think he did indicate that he did. That's the first point. Second point, Mr. Chair, is Mr. Gama is by his nature respectful. He is by his nature respectful.
Respectful.
At least from what I could see.
Yes, okay. Yeah.
And so when he says that he goes into a meeting and he will speak when he's spoken to, I wouldn't necessarily disbelieve that.
Yeah.
If he's in the meeting with the president, sir.
Yeah.
But if he's in a meeting with the BADC members, Mr. Chair, if he needed to speak about something that he needed to speak about, he would do so, in my view. And the reason he did not, in my view, again, Mr. Chair, did not raise this issue with the board was because of the fact that we had this pre-meeting that happened in the morning, or happened during the course of that day, relating to the update on the 1064s, as well as the 100 local.
Well, he might not have said this, I'm not sure, but could he have taken the view that he need not raise this issue, express his own view, because you and Mr. Brown-Molefe had already taken a view which was contrary to his? He should not go to the committee and raise a minority view. Is it possible that could be a factor, as what could have been a factor, to the extent that on his version he was not asked?
Well, Mr. Chair, from my perspective, as I sat there, we had come to the consensus view, given the meeting of the morning, that the route that we were taking was confinement to CSR.
Did you deal with this in any affidavit about this meeting that the three of you had in the morning, and about
No, sir.
You did not
No,
deal with it? And about the resolution that you say he signed after the event, you deal with that?
No, sir.
Okay, all right. Was there an affidavit of yours that responded to his, or there wasn't?
There wasn't an affidavit responding to his, Mr. Chair. I think we received a redacted version of his affidavit, and I think he only mentioned me once there.
Okay.
In fact, Chairperson, maybe just to place you in the picture, we received a extremely redacted version. If my recollection is correct, it was 2 or 3 pages. And we specifically again went on record and requested an unredacted version of Mr. Gama's affidavit, and I don't think we ever got it.
Okay.
All right.
Well, maybe on the face of it, it might not have well, I don't know, it might not, sometimes I think the experience within the commission is that sometimes very difficult to say whether an affidavit of one witness implicates somebody or not.
The one part that we considered, and of course these are judgment calls, we may have got it
Yes.
wrong.
Yeah.
Where we felt that Mr. Singh was implicated was in respect of Mr. Garma's version about the
Yeah.
office, the alleged meeting with Mr. Essa.
Yeah.
But certainly, Chairperson, from the legal team's perspective, we're not going to make any issue of the fact
Yeah,
that Mr.
yeah.
Singh hasn't set this out in his
Yes,
affidavit.
yeah.
What's more important, of course, is for us to try and make sure that we understand the opposing versions.
Yeah, yeah, yeah.
Mr.
No, it may have meant something if there had been occasion for him to respond.
Yes.
And he responded but didn't say anything.
The other thing, of course, is that it might mean that we need to direct an inquiry to Mr. Garma and ask him
Yes.
to respond
Yeah.
to this version.
I think that would be important.
Chairperson, maybe one more thing. I think my learned friend will bear with me. Yesterday morning, we requested or we inquired whether Mr. Garma made an affidavit pertaining to the 1064 or the 100 locos. And we were told that there is no such affidavit.
Mr. Garma. I'm not sure, I think my learned friend and I might have got our wires crossed. I mean,
Yeah.
they have Mr. Garma's affidavit.
I might be mistaken, but there was specifically a request about an affidavit, and my recollection, again, I might be mistaken, was in respect to the confinement of the 1064 and the 100 locos. I fully agree with my learned friend, he made an affidavit, but I'm not sure whether he made it in respect of this particular issue.
Okay, no, that's fine.
Well, I'm busy reading Mr. Garma's affidavit to Mr. Singh.
No, that's fine. You can obviously obtain a copy from the
As I said,
legal team.
Chairperson, I might be mistaken.
Yes.
Might have been pertaining to Mr. Peter.
Yes.
And then I apologize to my learned friend, but I recall there was an issue about that.
It did, in fact, as I remember, relate to Mr. Peter. My learned friend and I have ring-fenced a number of issues. Perhaps
Yeah.
we should leave it at that and see if we can sort them out afterwards.
Yeah, okay.
Mr. Singh, if I could just carry on with Mr. Garma's version, please. At paragraph 54.1, he says, I've read the minutes, particularly paragraph 5.22.
So
what page?
Page 250.
Terribly sorry, Mr. Madak.
Yes.
What I forgot to ask is, do we know whether Mr. Brian Molefe ever spoke when he was giving evidence about this meeting that happened among the three of them?
I've mentioned to Mr. Singh that to the best of my recollection, he didn't.
Yeah.
But that's something that I think we need to look at more carefully and perhaps ask him about as well.
Yeah. And Mr. Singh, do you know whether Mr. Brian Molefe got to know at some stage that Mr. Kama ultimately signed the memo that he had not signed at the time of the BADC meeting?
No, Mr. Chair, that would have been between Mr. Garma and myself, and I would have then
Okay,
submitted it to committee.
Okay,
Thank you.
okay.
So, Mr. Singh, I'm at 250.154, Mr. Garma's affidavit. Are you there?
And
All right, so let's pick up at paragraph 54.1. He says, I've read the minutes, particularly paragraph 5.22 of the meeting of 24 January 2014 of the BADC. Sub 2, it's clear to me that no one from TFR would have presented anything of the kind reflected in the minutes. As in by way of example, quote, management informed the committee that it was decided that a 26-ton heavy haul line by GE would perform better than a class 19E locomotive from Mitsui, close quote. The aforegoing caption is nonsensical in that not only is the heavy haul line not a locomotive, but also that General Electric GE only manufactures diesel locomotives, and therefore the specifications cannot be compared with those of electric locomotives manufactured, for instance, by Mitsui. Next subparagraph, again, he's quoting from the minutes, management motivated for the confinement in favor of GE This was motivated by a submission that was previously withdrawn due to reputational issues that had emanated from old newspaper article. Management requested for a contract extension for Class 43E diesel locomotives by CSR, end quote. From the aforegoing, it is clear that confusion reigned between the procurement of diesel locomotives by GE, 43D in brackets, and the procurement of electric locomotives either from CSR and or Mitsui. Consequently, no reliance ought to be placed on the aforesaid submissions, as they are clearly wrong and not representative of what had been discussed. However, what is significant was the fact that whilst I supported the confinement to Mitsui, the BADC had rejected my said proposal on the basis, as I understand it, that such confinement would have been the third with Mitsui. As it so happened, Brian Malefe later informed me that my Mitsui submission would have been stillborn. And then the last subparagraph 54.4, Singh and Malefe had removed my memorandum and prepared a new one, which they signed and presented to the committee, recommending CSR as the preferred bidder. You want to comment on any of that?
Mr. Chair, I think as the facts would point out that Mr. Gama was in possession of the proposed memorandum, or the proposed submission, which he commented to me, which I then forwarded to Mr. Molefe. His comments were then taken into account in the final memorandum that was then submitted to the BADC. Mr. Chair, what he highlights as the discussions in the minutes, in terms of being, I would say, nonsensical, it doesn't not make sense the way it is captured. So what in my view he's alluding to is the fact that the minutes incorrectly capture the discussions that were occurring at the BADC. It does not mean that the submission that was presented to the BADC contained these errors.
Well, I'm not sure that that is necessarily correct. I read what he says as premised on him saying, this is the basis on which this decision was taken. Look what was being said here.
Hence, Mr. Chair, I say, okay,
It doesn't make sense. Maybe I'm being unfair to him, but that's how I read it.
being unfair to?
To Mr. Gama, because the interpretation I put to what he says, I attach to what he's saying, makes him critical to those who made the decision, or maybe those who presented the case, whereas the interpretation the meaning you attach to it is more about the minutes and not about the people.
Well, hence, Mr. Chair, the people could have only got this from the submission. So the submission is actually, I think you took us to the submission. It was that long one that
After that.
yes.
The
So,
submission is at page 244.
but in a different bundle, right?
It's in Callard's bundle.
Yes. 244.
Would they not have sought to capture what was said at the meeting as opposed to what was in the memorandum?
Sorry, I couldn't hear you, sir.
Would they not have sought to capture what was said at the meeting as opposed to what was written in the memorandum?
Well,
Those who prepared the minutes.
Well, Mr. Chair, I can't comment for what they had captured,
Yeah,
but I can certainly comment on what was presented.
yeah.
Because what was presented was what was physically signed by myself, which is basically contained in 244 right through to 267. And Mr. Chair, you will see the reason why the references to GE come into the minutes is because we were asking for two things to happen. So confinement to CSR for 100 locomotives, 19 equivalents of 26 axle ton locomotives, and class 43 diesel locomotives from GE. So there were two confinements that were being done at the same time with one memo. So when the discussion was being recorded, I would assume that they were confusing CSR with GE and GE with CSR. And that's the reason why this is the way it is.
And you would not have corrected the minutes when they were circulated?
They should have been corrected.
But do you remember having raised the issue? Because I assumed that having attended, they would be circulated to you as well.
I think they would have been circulated to me, Mr. Chair, but I don't recall having
Okay, Mr.
corrected
Mattek.
them.
Yes, thank you. And then let me take you to two other passages, please. Page 250.168 of Mr. Gama's bundle.
250 point.
250.168. Right at the foot of the page, he addresses the issue of the acquisition of the 100 locomotives again at 77.1. TFR had set out to procure 100 locomotives from the coal line from Mitsui in line with the 19E acquisition. The BADC determined that we had utilized confinement as a procurement strategy with Mitsui on two previous occasions, and that this did not permit a third acquisition from Mitsui. The GCEO and GCFO subsequently requested a confinement to CSR, and the BADC agreed to the request. The decision was taken whilst I was protesting the appropriateness of the request, having regard to the fact that CSR had no established history with the provision of similar locomotives in South Africa. Subsequent to the approval of the aforesaid request by the BADC, which motivated its decision to the board, Transnet's technical design team engaged with CSR to create prototypes whereafter the locomotives were delivered and employed on the coal line. They were named 21E series. Do you want to comment on any of that?
Mr. Chair, again, you will see that this issue of the reason, Mr. Gama now introduces a new reason regarding the CSR decision, in that CSR had not developed these type of locomotives before, and he had a concern. This is now an additional concern compared to his concerns that he had on the 23rd of January in the email that he had sent to me. Mr. Chair, also, I think when he says that Transnet technical design team engaged with CSR to create prototypes, where after the locomotives were delivered and employed on the coal line, I think I take issue with that, Mr. Chair, because you will have a reference to a document that I have included in my affidavit, not for this purpose, but it does address this concern that Mr. Gama has raised here. It refers to a, maybe we can actually find it, it will then make it much easier. Do we know where Harris report, in which affidavit the Harris report? Mr. Chair, just, I beg for a couple of
Your legal team will have a look. If they find it, they'll let us know.
Okay, it's Harris report. Harris report. I think it's in the 100 or the 1060.
So, Mr. Chairman, I mean, perhaps we should if you'd like to take a short afternoon break for 5 or 10 minutes, and we can sort this out so that Mr. Singh and his council can be afforded an opportunity to converse.
No, I think let's continue. If they haven't sorted it out by 4 o'clock, when we take the short adjournment.
All right.
Yeah, let's continue for now.
Sure.
So, Mr. Chair, while we look for the report is, well, we've termed it the Harris report. It is a report from Mr. Frikkie Harris. Mr. Frikkie Harris, I think, was the program director of the capital program within TFR. And the purpose of that report, Mr. Chair, was to evaluate the technical submission from CSR. So remember, this is how this would have happened. As I explained before, the confinement happens on day one. So the confinement is approved. Once the confinement is approved, then an RFP relating to that confinement is prepared. So TFR went off and then prepared a request for proposal relating to the confinement of these 100 locomotives that we then required from CSR. I think that letter was then signed by Brian sometime in February and dispatched to CSR. CSR then would have had to respond with the requirements of that RFP for the 100. One of the returnable documents of that 100 RFP, Mr. Chair, I would assume, was the technical specifications of these locos. What would they do? What would they not do? How do they do it? And so on. And it was this Harris report, or Mr. Frikkie Harris's report, that effectively assessed technical requirements or the technical operability of these locomotives with the current 19E Mitsui locomotive. And Mr. Chair, that report basically found that the 21E locomotives that were actually proposed by CSR were actually acceptable and adaptable and operable with the 19E Mitsui locomotives that were currently deployed on the coal line. So it did find one exception, which I think was a minor exception, but overall it said it was operable or interoperable. And when we find the report, we can read you the final conclusion of that document.
Okay.
Thank you. And then could I take you, just to end off on Mr. Garma's version, to page 145 of his bundle, bundle 7.
145.
145. Towards the beginning.
And yes,
Are you at 145?
yes, sir.
I'd want to direct your attention to paragraph 30.2.1, the top of the page. The written recommendation to procure 100 locomotives.
Sorry, sir. You are at 145.
145.
In Gama's.
Yeah, forget about 250 point something.
Yeah.
Go back to just 145.
Okay, 145.
In
But
his,
it starts with paragraph 37.
No. It
have you
starts
got
with
his
paragraph
affidavit?
30.
It's page 30 of his affidavit.
Page 30.
Of his affidavit.
Okay. Page 30 of his.
Of his affidavit. Can you see paragraph 30.2.1?
No, now I've got paragraph 64.
Is there somebody who can help him?
Oh, sorry. I'm there, sir.
All right. That paragraph 30.2.1, Mr. Garma says, the written recommendation to procure 100 locomotives from CSR was signed by the CFO, Mr. Anoj Singh, and the GCEO at the time, Brian Malefe, in circumstances where I was of the view that CSR did not have the capability to manufacture heavy haul locomotives. You want to comment on that?
Well, Mr. Chair, again, as I would bring you back to that email of the 23rd of January, where Mr. Gama did not raise the issue of CSR's ability, manufacturing ability. He just raised the issue of the fact that CSR would need to manufacture most of these locomotives offshore rather than do it at TE, which would impact on our localization objectives. This is introduced as a new concern, in my view, as he had not raised it with us in the email, nor had he raised it at the BADC meeting or at the meeting before that. And as you would see in the Harris report, Mr. Chair, that the CSR did have the ability to produce heavy oil locomotives, and Harris actually in fact signed off on the fact that the technical specifications that were submitted for the 21E locomotives was interoperable with the 19E locomotives on Mitsui.
And then at 30.2.2, I was informed by the GCEO that Mr. Sharma, the chair of the Disposal and Acquisition Committee, had not permitted any further procurement by way of confinement from Mitsui. I deny that I was responsible for making a recommendation to the ADC and that I failed in my fiduciary duties during the acquisition of the 100 locomotives from CSR as alleged. Perhaps I could just ask you to comment on the first part first. He says he was informed by Mr. Molefe that Mr. Sharma would not permit any further confinement to Mitsui.
Mr. Chair, I cannot comment on what Mr. Molefe had either discussed or didn't discuss with Mr. Gama.
Mr. Sharma.
I mean, Mr. Sharma. So I can't comment on that.
Did he express this view at the BADC meeting, Mr. Sharma?
Mr. Chair, my only recollection is from the documents that have been presented regarding this matter, and the BADC meeting that happened in October 2013, where the Mitsui confinement was either served or didn't serve and was withdrawn, would be where this type of conversation I would expect would have happened. Unless there was a conversation that happened outside that meeting, I don't know.
Mr. Singh, this is an issue that you deal with in one of your affidavits. Perhaps I could take you to page 5C, page 1465.
Unified.
Files are stacking up.
Page, sir? 15?
1465. So before we deal with the content, perhaps I could ask you, why is it that you supported confinement to CSR?
Mr. Chair, in my view at the time, there was obviously the issue of the revenue at risk. And it was becoming more and more urgent that we actually address this issue. So from that perspective, Mr. Chair, I believe that the grounds for urgency relating to confinement would have been met. In terms of the change from Mitsui to CSR, Mr. Chair, to be quite honest, I was actually indifferent. As I supported the memo to Mitsui in October, which was then withdrawn or was not approved, whichever the case may be, for me, I was indifferent between either one of them. Mr. Molefe gave the instruction. I didn't really find difficulty with it, Mr. Chair, because of the history that we had with Mitsui. We had occasion to acquire locomotives previously from Mitsui, 110 coal line locomotives, which is the 19Es that Mr. Gama speaks about and Mr. Kellard speaks about. And we also, I think, acquired, if memory serves, 45 iron ore locomotives for the iron ore line, also heavy ore locomotive. Mr. Chair, we did have, if memory serves, quite a significant, not quite significant, a number of issues with the locomotives in terms of commissioning. And there was an inordinate amount of delay in terms of commissioning these locomotives. If I recall correctly, Mr. Chair, again, I'm speaking of stuff that happened years ago, there were penalties that were actually levied against Mitsui for the delayed or the late delivery of these locomotives. There were issues relating to, I can't remember the technical issues that related to why these locomotives were not being commissioned. But again, the reason why I got to know about these things is because it had an impact on the ability of freight rail to deliver volumes. And that became a financial issue in terms of the budget again. And the second issue why I was aware of this, Mr. Chair, was when they had a contractual dispute in terms of the penalties that needed to be paid. I then got involved in trying to arbitrate or mediate between Mitsui and Transnet in terms of what the value should be. I don't know what the value actually ended up being, but I think, if I recall correctly, some amount was paid by Mitsui relating to these locomotives. So it was a historic issue in terms of being able to have comfort that Mitsui will deliver these 19E equivalents without the issues that we had previously. Secondly, Mr. Chair, the proposal that, if I recall correctly, that came from Mitsui relating to the new batch. Remember, there was 110 that came and was delivered, had problems. We're now ordering a new batch of 100. And these new batches, Mr. Chair, if I recall correctly, in terms of the offer that came from Mitsui, because the delivery timeline relating to these locos had now been compressed, there were numerous conditions that came in the offer. Like, for example, they had not yet received the approval of their subcontractors in terms of being able to deliver these locomotives. So they still needed to engage with their locomotives. We needed to sign the notice to proceed by a certain date in order for them to do what they needed to do to deliver the locos by a certain date. In order for them to meet, let's call it the aggressive delivery time frame, they needed to take existing 19E locomotive parts that was in Transnet's stock to put them into the production line to produce these locos. Now, Mr. J, in my mind, if you already have a problem on the coal line where it's not meeting its budgeted volumes, then you're going to take parts that you may require for the current existing fleet to be able to meet the already underperforming coal line to mitigate the very same risk. You're actually perpetuating the risk if indeed the locomotives do break down and need these parts. So, Mr. Chair, the 19E, let's call it revised proposal from Mitsui, came with its own set of risks that, in my view, just increased the operational risk relating to the volumes at risk. So that was the reason why, Mr. Chair, I didn't really feel indifferent between Mitsui or CSR.
And you express those views in paragraphs, in particular 52 of your affidavit, correct?
That is correct, sir.
So you say my confidence levels in Mitsui being able to meet its proposed very aggressive delivery schedule was low due to the following, and you set those reasons up.
I'm sorry, you're reading from...
Page 1465, which was
Oh, okay.
bundle
Oh, yeah, now I see.
5C.
Okay, I'm there.
Mr. Singh, do you wish to highlight anything further, or I think you've addressed those points, have you?
I do, but now that we're here, I'm just looking for the reference to my Harris report.
Harris. But I see it's almost 4 o'clock, so you'll get a chance to...
But you continue, I'll find it at T.
Can I now take you...
I'm sorry, Mr. Maipek. What you say, Mr. Singh, in Prof. 153 doesn't seem to be consistent with what you have just said, namely, you were indifferent whether it was CSR or Mitsui who got to do the job.
Mr. Chair, this relates to the reasons why I believe the confinement would be appropriate to CSR, in addition to the fact that there was urgency.
Yeah, but I understood you to be saying ultimately your attitude was really, it didn't matter much to you whether ultimately it was CSR or Mitsui who got the job.
Yes, Mr. Chair. In my view, at the time, whether we were going with Mitsui or whether we were going with CSR, we were still going to procure them on the basis of urgency. Because the coal line volumes were at risk, the 1064 locomotive program was behind schedule. So the only way to mitigate that risk was to actually get the locomotives.
Or you are saying that you are saying that what you were saying related to the ability of either to deliver.
Exactly.
But here you are dealing with the issue of urgency in relation to each one of them.
Yes.
Okay, all right.
Could I then take you to the Ndutsi report?
Would this be the right time to take the 10 minutes, Adjournment?
Thank you,
We
Chairperson.
didn't talk in the morning about whether you were able to make a plan and be able to ensure that we can continue.
Person, I'm not sure if we discussed it in the morning, but I ultimately were able to ensure that we can sit till 5. I couldn't extend it beyond that. I think
Until
I
5.
told my learned friend, I'm not sure.
How are we doing in terms of how much time do we need?
Well, we're not going to be finished by 5, I'm
By
afraid.
5, but how much time do we need? And this is not to put pressure, just want to assess so as to take a judgment call as to what should happen.
So DCJ, I think that we'll probably finish the 100 locomotives in an hour.
Yeah.
Because we still need to deal with the 1064 locomotives. And
Yes.
that is a big chunk of
Yes.
evidence that needs to be led,
Yes.
particularly around the increase in the ETC.
Yes. Well, and that part that we will not have finished, we will not have started after an hour.
No.
Would it need half a day? Would it need a day? What's your assessment?
I would think it can be done in less than a day.
Yeah.
I think that what needs to be done
Yeah.
is to find a way to present to you, maybe in a form of a schedule or something,
Yeah.
the various different versions in relation to the increase in the ETC. There are 2 expert reports, etc. So,
Yes.
but I think that could be done in a few hours. I don't think we need a whole day at DCJ. I think we need
Yes.
at least half a day. I
Yes.
don't know if we could fit it into a night session.
Yes. Well, that suggests to me that we should do as much as we can today because we don't have time. I think what you may have to consider is whether if you have to leave at 5, and of course your client might have to consider that as well. I assume your instructing attorney doesn't have to leave at 5, whether we could proceed in your absence, but in the presence of Mr. Singh's attorney, on the understanding that if, as we go along, Mr. Singh, there are questions that he is uncomfortable to answer without talking to you, we could take it from there, but we try and make as much progress as we can. Obviously, the transcript can be available for you to look at afterwards. Maybe let's adjourn, and then maybe you can talk to me, all sides can talk to me in chambers, but we have to try and do as much as possible. Okay, we adjourn.
Callard, you say, gave input to changing it.
Well, Mr. Myburgh, you recall.
Remember, Mr. Callard was very upset that.
Yes,
it
but
had been
Mr.
changed.
Chair, this was the point at which Mr. Callard realized that CSR or Mitsui had been changed to CSR based on the paragraph we read before. So I'm saying Mr. Mdleche and Ms. Callard, Mr. Mdleche and Mr. Callard were TFR employees. So the memo had been amended at TFR.
But are you suggesting that Mr. Callard may have been involved in changing it?
Well, Mr. Chair, he admits that Mr. Mdleche sent the document to him for some input. Whether he provided that input or not, he doesn't say. But eventually the same memo is the same memo that he then complains about to Mr. Gama a day later, after he agonized over it at night on his version.
So what we have, if you go to FQC 09, perhaps can you go back to that, please? It's Exhibit BB4A.
Yes, we did. Yes.
So he says at paragraph 39, on the morning,
What's the
Wait.
page number? Page number?
sorry, I beg your pardon, page 9, DCJ.
Okay.
So what he says at 39 is on the morning,
Sorry, 39.
39,
Oh, sorry.
page 9, paragraph 39.
Okay.
On the morning of Wednesday, 22 January, I received a mail from Mdleche from Supply Chain Services requesting my assistance in formatting the memorandum. When I perused it, I noticed that the memorandum had been changed to give effect to confine the award to CSR. And then we know what happens after that. Are you saying this reflects that it was changed at TFR?
Well, I am confused because I've stated that I received, so I read from paragraph 39, correct?
Yes.
I received a mail from Lindiwe Mdleche from Supply Chain Services. Mr. Mdleche is a TFR employee.
But what I'm trying to get at, are you saying it's TFR? I mean, I don't know what this person did. They might very well have affected changes. But these are not TFR-driven changes. I mean, your own evidence is it's you and Malefe.
Yes, but I'm saying that the changes that were affected,
Yeah.
if we needed to change from CSR to Mitsui, would be an instruction.
Yes.
But if they needed to be, as Mr. Gama said, 19E and 20E axles and this and that and everything else, that would come from TFR.
So Mr. Garma says, as the CEO of TFR, that he did not support this change.
But as we've read, he sat at the BADC, he got the memo. He commented on the memo.
All right. Well, I suppose
He
the
subsequently signed the memo.
Fundutsi report shows up the problem. And let's go back to page 130 at bundle 6. So just so that you appreciate this, I read paragraph 5.6.9.9 to Mr. Garma.
So you are now at one,
Back to page 130.
and you are at paragraph?
5.6.9.9, and then we get to what is the problem, one way or the other. It's either a problem or it would be resolved by your evidence if it was to be accepted. At paragraph 5.6.9.10, we determined that as per the Procurement Procedures Manual version 2, October 2013 requirement, the end user, in this case TFR, should be the one motivating the procurement process to be followed, i.e. confinement or tender, before the memorandum may be taken to the Transnet Group for recommendation to BADC. We determined that Gama and Gianni as the end users did not motivate for the confinement of 100 locomotives to CSR. Your comment on that?
Well, Mr. Chair, I would assume that that is arrived at by virtue of the fact that Mr. Gama did not actually sign the memo.
Well, also arrived at by the fact that, according to Mr. Gama, if you go to paragraph 5.6.9.9, the memorandum dated 21 January 2014 to confine to CSR was changed at Transnet Group and not at TFR.
So where are you, sir?
5.6.9.9, the paragraph immediately above it.
5.6, 9.9. Oh, yes, yes.
Yeah.
But that does not accord with Mr. Mlete having access to the memo.
But Mr. Singh, I don't know, perhaps it's too late in the day, but was it you and Mr. Malefe that wanted to change the memo initially?
The decision to change the memo, as I already explained earlier, was taken by Mr. Molefe
Right.
in saying, let's confine to CS.
Okay. So that we know.
Yes.
The memo has changed.
Yes.
We know that somewhere along the line it seems that Mr. Callard gets wind of this and he complains to Mr. Gama.
Right.
So it's Mr. Malefe's instruction.
Yes.
What did you do?
As I explained before, when he did say that, I would have then instructed, I would have either communicated with someone in group procurement, who would have then communicated with the TFR in terms
Yes.
of the instruction.
But the point is, it's a group decision. I mean, whoever did the word processing, that's not what's important here.
Yeah.
This is, I understand it, you must correct me if I'm wrong, because it's an important piece of evidence.
Yeah.
Your version is it's a group decision by Mr. Malefe and then furthered or carried out by you.
Agreed.
Correct?
Correct.
So who did the word processing you accept is not the issue?
Well, I need to understand what your proposition is, and then I can say to you, word processing is of no consequence.
Well, the point,
I seem to remember, I don't know whether it was Mr. Kalat or somebody else who was giving evidence during the first phase, now that we're talking about it. I seem to remember as if somebody testified that an instruction came from, I don't know whether from Mr. Molefe or from group level, to either TFR or to a particular person to say,
Amen.
change the memorandum. I seem to think that, but if that is what happened, it would accord with the decision having been taken at group level.
We had one with Mr.
And whoever else having to maybe give effect to it, if that was the case. But one might have to double check. What seems to be clear, one, from the fact that it's people at group level who signed it, at least at the time the matter went to the PADC, to, on your own evidence, it was Mr. Molefe who took the decision.
That is correct. So we had one regarding
My memory might be wrong, Mr. Maybeck, but I'm just saying, I seem to think that I had evidence of somebody who was unhappy that they were being made to effect changes that they were not happy with, but had to comply with instructions or something like that.
Mr. Chair, I don't think we dispute that. The decision was taken at group,
Yeah.
so that we do not dispute.
Well, if the decision was taken at group level, then I assume that if the changes were made below that, it would only have been on instruction, I would imagine.
Well, Mr. Chair, that's correct.
Yeah, yeah.
The previous discussions that we were having, Mr. Chair, regarding the issue of the changes, in my understanding, related to whether Mr. Gama was aware of these changes or not
Yeah,
prior to the BADC meeting,
yeah,
and not as to whether the instruction had come from group or not. I think that I was clear about, that
Yeah.
the decision was made by Mr. Molefe, it was communicated.
yeah, yeah. But what it would mean, what it may mean, might be that if Mr. Gama did ultimately go along, maybe if the boss has decided, maybe the boss has decided, I don't know.
Well, Mr. Chair, he did send a mail to say these were his concerns. So he was at liberty to say no. If he had said his concerns, Mr. Molefe was also aware of the concerns,
Yeah.
because I sent the mail to him. So
Yeah.
he was at liberty to say no at any stage.
Mr. Mabeck, I may have thrown you.
I was trying to find what I thought you had in mind, DCJ, but alas, I have not been able to.
Yeah, unfortunately, my memory is not so helpful today.
If we carry on then at page 130, the next subparagraph, 5.6.9.11, we determined that paragraph 15.1.5 of the 2013 PPM states that, quote, the submission for confinement must be fully motivated in writing by the end user and the operational division chief procurement officer, TFR, in brackets OD, CPO, close brackets, to the operational division's OD's main acquisition counsel, AC, and the operational division's chief executive officer, ODCO, TFR, for prior written support for the recommendation to confine. The submission should be submitted on the relevant template under cover of a memo to the GCE. Now, do you say that happened?
Mr. Chair, this would have, in my view, happened through the document that was submitted to Mr. Gama on the, I think it was the 22nd, which he then responded on the 23rd with his 3 comments. Furthermore, Mr. Chair, I did forward the 3 comments to Mr. Molefe the same morning, and the meeting that occurred pre the BADC was again the subject of the discussion of the 100 locals. Mr. Chair, again I submit that the requirements relating to the PPM of OD involvement and sign-off was achieved in some way through the pre-meeting, as well as the attendance of TFR at the meeting, where they did not raise any concerns relating to the matter. If you read on in the Fundudzi report, Mr. Chair, you will see that they actually do raise this issue of Mr. Gama actually attending the meeting and not raising any issues.
Did Fundudzi report get your version? I mean, did the Fundudzi investigators get your version?
Mr. Chair, they did provide me an opportunity to comment. We did comment on very limited aspects there. I think it was just on the issue of, we did not comment on the locomotive or any Transnet related matters. We had commented on the Eskom report, I think. But I'm not too sure, but we did comment on the issue of the FNB bank account, if you recall.
Okay.
If we could then deal with the increase in the ETC from 3.8 billion to 4.8. We know that the tender was then awarded to CSR on the 17th of March. And Mr. Leher gave evidence that afterwards you requested him to prepare a memorandum explaining why there had been an increase from the business case submission to justify what had been agreed. Confirm that?
That is correct.
And then we know that on the 23rd of May 2014, you approved a memo to the Board of Directors for an increase in the ETC from 3.8 to 4.8.
Supported.
3.8 to 4.8.
I don't think I approved, I supported a memo.
Okay. Let's go to that memo. Now, that memo you find in many different places, but perhaps it's easiest for us now to go to the Chaubi bundle. That is Exhibit BB 8.2.
Just do some housekeeping here.
Are you there?
I have the file.
And then if I could ask you, there should be a divider in there. We go to number 2, the second part, and I only have red pages. It's page 100-23.
100?
23, right towards the back. In fact, I think it's the last document.
100-23.
Are you there?
Yes, sir.
And let's go to the end of the document at page 36. This is recommended by yourself on the 22nd, is it, of May 2014,
Yes.
also by Mr. Gama, and then also by Mr. Malefe.
That is good.
And what you were proposing to the Board of Directors is that you recommended to it, that the Board of Directors take note of the main reasons for the increase in the ETC is due to the exclusion of the following costs from the 24 January 2014 submission, and they are then set out. And B, the Board of Directors approve an increase in the estimated total cost ETC for the acquisition of the 100 locomotives from 3.871 billion to 4.840 billion, correct?
Correct.
And if you then go back to page 23, you'll see, as you correctly pointed out, this really then comes from Mr. Malefe, you and Mr. Gama having also recommended it to the Transnet Board of Directors.
That is correct. Sorry, sir,
And
can
it was then a...
Sorry, Mr. Maverick. Is there?
Yes.
You need water?
It was just, if there was one available, it's fine, else we can continue.
Yeah, there should always be water. Yeah.
Thank you, Chair. We can continue.
So this was a memorandum that was then prepared between the 17th of March, when the LSA was concluded, and the 22nd of May, correct?
That is correct.
Now, so it was over a 2-month period, or took 2 months. Mr. Leher's evidence, I don't know if you quibble with it, is that you asked him to assist with the production of this memorandum, and that you would send him text as to what had to be typed in, and you would effect the amendments, etc. Is that correct?
I think the sequencing in events is probably what I dispute, but I don't think I dispute the fact that I would have sent him notes.
And I think you've accepted already, I don't know if it's with reference to this or the 1064, but I think we did deal with broadly, we spoke about the ETC increase memos, that this was your product, your work product.
In terms of the preparation of the document?
Yeah.
Yes.
I mean, both, certainly Mr. Gama and I think Mr. Malefe as well said, look, this is financial stuff. It comes from Mr. Singh.
Yes, Mr.
Okay. Now, what we need to just work our way through this document, but what I would ask you to comment on is paragraph 14. So, and this applies also to the 1064, remembering that these two acquisitions run in parallel. Paragraph 14, a contract to acquire 100 electric locomotives was concluded with CSR E-Loco Supply Pty Limited on 17 March at a cost of 4.4 billion, including the cost of future escalations and foreign exchange hedging, thus resulting in an increase of 969 million. Something that I think we're grappling with, and perhaps you can assist Mr. Singh, is what is the point of going to the Board of Directors to ask for close to R1 billion increase in the ETC once the contract has already been entered into? I mean, what is the board supposed to do? I mean, what would happen if they say no?
That would be an interesting question if they had said no. I guess the issue is, Mr. Chair, is that practically it's very difficult to estimate the cost, the exact cost of capital equipment, given the fact that there is a long lead time between the the long lead time between a business case that's actually approved, on which the procurement event is premised, and the actual conclusion of the contract. And thereafter, the conclusion of the contract to the actual delivery of the product. Because that entire time frame, Mr. Chair, has to be quantified in financial terms to be able to understand what is the actual final cost of the product. So you have to keep track of this, of the financial impact from the, let's call it, the business case approval date and the assumptions contained therein, right up till the date on which the last locomotive or product is going to be delivered. Because the financial impact thereof is actually only known on the last day that that product is actually delivered. So when the board is sitting and approving these things, Mr. Chair, they actually approve it on the basis of the information that's available to them at that point in time, with an understanding that economic variables that change over that period of time would impact that cost.
Yes, but that doesn't answer my question at all. I mean, I think you can accept that evidence has been led, and certainly from the legal team's point of view, we understand the initial business case and initial ETC and the need to increase the ETC. I can understand that. And I think it was explained well by Mr. Malefe and Mr. Coleman. But my concern is a slightly different one. I mean, I think you accept that you had to go to the board to get approval for an increase in the ETC of R1 billion.
Yes.
But then surely it must follow that Mr. Malefe and you had to go to the board before you signed the contract which included that increase of R1 billion,
Not necessary.
right?
So if the board had delegated the authority to negotiate and not conclude, you would have to go back to get an approval to conclude the contract. In this case, in both cases, the locals were delegated the authority to negotiate and conclude.
So you must just mark those words, negotiate and conclude, because we're going to deal with that. So you say that's what happened.
Yes.
But then why weren't you coming to the board to say ratify my conclusion of the contract? That's not what you're doing. You're
No,
asking,
remember, this has got nothing to do with the contract.
right?
This has got to do with the fact that the board, in terms of the delegation of authority, approved a capital equity.
Yes,
Remember, the procurement event is now done.
right.
It's finished. So there's no comeback on the procurement event, because remember, the procurement event said negotiate and conclude. It's now negotiated and concluded. However, the board, in terms of the capital allocated to this project, had approved in this case, a 3.8 billion rand number. Okay? But now that 3.8 billion rand number through the procurement process has changed.
Yeah. Well, it had changed because you had concluded a contract as
Yes,
well.
exactly.
Well, perhaps you're now speaking past one another. Let me put the question another way. What would have happened if the board had said no?
So the point is, again, the board would not be able to say no unless they had.
Well, that's the problem.
But that can't be right, Mr. Singh.
No, maybe let's
That can't be
rephrase.
right.
Let's rephrase, Mr. Chair. They would have raised concerns if, and probably they would have had the prerogative to say no, provided that we acted within the confines of the originally approved business case.
Well, Mr. Maybeck will follow up, will pursue his line of questioning. Why couldn't all of these matters be provided for before the conclusion of the contract? Why couldn't, I mean, you always provide for escalation of this and that and interest and so on. Why could all of these things not have been placed before the board if they were not placed before it made the decision, so that once it has made the decision, it has a clear picture of the risks that could happen post the conclusion of the contract, economic or otherwise, because they have approved the contract fully aware of various risks, but have provided for how those risks can be dealt with. Why could that not be done?
I think, Mr. Chair, it comes back to the issue of the timeline that it takes from the conceptualization of a project, estimation of the cost of that project at conceptualization and approval of the business case, and up to the point at which you then actually contract.
Yes, but at the time you say to the board, approve, here's a contract. Why should they not have a full picture and decide whether they approve or not,
Well,
including potential risks, and then see how those potential risks can be provided for?
Mr. Chair, I think
Because, I mean, many contracts get concluded in circumstances where there are risks that can be predicted, that they are likely to happen. There are others that are unlikely, and there are others that are unthinkable but can still happen. COVID-19 can happen. But the economic situation can be taken into account, that the economy can change and so on.
And that's exactly well, Mr. Chair, there is one other factor. Well, actually two other factors that I may add to your summary. One is let's call it the maturity of the designs relating to the underlying product. Okay? So if you were building a house, Mr. and you had very rudimentary plans, and you went to a builder and said, build this house, he would give you an estimate. But given the fact that the plans are very rudimentary, you must also understand his estimation would be less than accurate. Whereas if you had very developed plans and you said to him, listen, I want this type of wood and I want this type of tiles and I want this color and I want it from here and I want it from there, his quote would be actually much more accurate.
Oh, that's fine, but when I approve that you can go ahead and build the house, I must have a full picture.
No, that's the problem, Mr. Chair. You sometimes don't have that certainty.
No, but he certainly can say the building material as at this date costs so much. It's going to take 9 months to finish this house. Maybe in 6 months' time there can be an increase, maybe 10%, because in the building industry, construction industry, this is what happens during certain times of the year. And then I can make provision.
So, Mr. Chair, let's take that example. Let's say he has rudimentary plans, right? And you decide you want to build your house here. And on this
Well, the rudimentary plans must belong much earlier. But when I say go ahead, I must have final plans to say, this is the house that I want it to be built like this. This is what it's going to cost me. If there is going to be a change in cost, it's about 10% or 20%, 15%. I provide for that. I say I'm fine.
Yes. Unfortunately, Mr. Chair, in the example we used when it's our own house, then maybe we have the luxury of waiting until the plans are more developed. But the point is, and the principle that you do take, is that if you don't have those mature plans, you then have a greater degree of uncertainty relating to the cost. Now, if you look at projects like Medupi and Kusile, for example, Mr. Chair, as well as the NMPP at Transnet, as well as previous locomotive procurement at Transnet, the biggest problem was design maturity. To the extent that you do not have mature engineering designs, you will constantly have escalation in cost. Mr. Chair, that was one of the issues. The other issue that you picked on, Mr. Chair, that I would like to, and it's pertinent in this case, is the issue of economic variables and how do you predict it. Now, Mr. Chair, if you look at the rand, it's a very volatile currency against any currency in the world. Now, when you are predicting from, in this case, the business case, I think, was approved in May 2013. And it was premised on the Mitsui quote that we originally received from Mitsui at the time. And it was premised on the estimation of what the currency was at the time in 2013, compared to the Japanese yen, which resulted in this 3.8 billion number. Okay? Now, the procurement happened in March 2014. So it's a whole year. And the currency has obviously changed, the currency has obviously moved. Another thing that is difficult to estimate at that time, Mr. Chair, is not knowing what the actual delivery schedule of the locomotives is what is the cost associated with actually hedging these, and what is the cost of actually the escalation associated with it. Because you can only take that decision, Mr. Chair, on the date on which, or very close to the date on which you are actually contracted. You can have a view of it, and you can include something in the business case. But that is always, again, subject to estimation risk. And what we are quantifying here, Mr. Chair, is exactly that. It is estimation risk that was included in the business case. Barring, in this case, there was one cost relating to modifications. The rest of them really related to quantification and estimation.
Mr. Maybeck.
Thank you, Chairperson. I see that it's just after 5. If this would be a convenient point to adjourn.
I know that you were following up and I may have interrupted you.
It's something that I need to reflect on and certainly have a look and see what powers were delegated to Mr. Molefe.
Yeah, okay, all right. Okay, let's adjourn for the day then, and we will continue at 4 o'clock on Monday. For the benefit of the public, one, we don't have an evening session today. And on Monday, the hearing will only start at 2. We adjourn.
I'm gonna take it all because, I need to work on this on the weekend. And then when I come back, I'm just gonna use the ones that I